Check, check. Hey. Check, check, check.
Hello, thank you for coming, and a very warm welcome from us, from NAԻMA, that you made it, and thank you all for those of joining us through live stream. We have realized that we do have a substantial amount of people signing up for live stream due to strikes in France and also to EU-related events. There will be more people coming in on in the afternoon. So we are very pleased that we have assembled a panel of high-caliber speakers to guide us through our theme. We got a very positive response throughout not just a legal community, but also business community and media that we have taken on this challenge, I have to say, to set up this conference. Let me introduce you myself. My name is Uwe Wolf. I'm the CEO of NAИMA Strategic Legal Services in Berlin, a company that's specializing in litigation, PR, and legal communications. And we are the initiator of the European legal debate. As you can see, it's the first European legal debate. It's a new discussion platform we plan to use for other topics in the future. So today we are talking about Russia-related sanctions, a topic that is as topical as it is intensely debated. Why did we decide to do this? We believe such discussions, I'll put this way, must be conducted broadly because they touch on the foundations of our legal system, and thus ultimately the values on which the European Union is based. In this respect, such discussions are always also a way of reassuring ourselves where do we stand, what do we stand for, and what makes us unique. Especially in times of crisis like these, it is essential to question the law we have given ourselves and to compare legal and political measures with it. This is essential also for our credibility and the persuasiveness with which we as a community confront the opponent of our free democratic basic order. Let me be clear, probably no one in this room will fundamentally question the Russia-related sanctions. They are an important and potential powerful response to the war of aggression that Russia is waging against Ukraine in violating international law. A tough and swift response to the breach of civilization in the middle of Europe is and was necessary. What we should not do, however, we should not turn a blind eye to the inaccuracies and inconsistencies in what we are doing. The sanctions have been decided and implemented in a hurry and under tremendous political pressure. Everyone can understand that mistakes are made in such a situation and under such pressure. And certain consequences are not thought through. One example in this is a criteria for which individuals and companies end up or have ended up on the sanctions list. It's no secret that Google has played a major role in that. One of the fundamentals of our law is that you have to justify why someone is punished or sanctioned. No goal and no morality, no matter how lofty, can justify concessions here. Our law is uncompromising at this point. Where evidence or proof is lacking, where inadmissible labeling takes place, or where nationality alone becomes the criterion, we leave the safe ground of our law and thus make ourselves vulnerable to attack. In recent months, sorry for that, we have been contacted by many lawyers who have expressed legal concerns. The prohibition to provide legal advisory services, for example, and thus the restricted access of an affected person to a lawyer was particularly strongly criticized. This is quite contrary to the core of a constitutional state. The criticism in the legal community became louder and culminated recently in an open letter from EU defense lawyers to the EU Commission. Two of those signatories, William Gillier from Paris and Gabriel Lansky, here, from Vienna, will also speak today. William Gillier will explain later why the defense lawyers wrote and published this letter. So we listened to the complaints and the swelling unease of the legal profession and wanted to know more about the Russia-related EU sanctions. To that end, we commissioned two renowned international active criminal lawyers to take a closer look at the sanctions regime. They are Anna Oehmichen, over here, from Oehmichen International in Germany, and Salomé Lemasson from France. Anna Oehmichen will present the expert opinion immediately afterward and report on her adventurous trip to the land of sanctions and those who were sanctioned. We will discuss different aspects of the expert opinion during the day. We did not create this event to engage in sanctions bashing. Quite the contrary. Instead, we want to offer constructive criticism and talk about suggestions of improvement. We want to help strengthen the sanctions to make them more resistant to attacks from rightly sanctioned individuals or companies. We want to help ensure that the sanctions regime accurately reflects the rule of law from which it was born. I look forward to the presentations and the discussions, and now hand over to Dr. Klaus Zimmermann, who is so friendly. He is from the law firm NER in Brussels, and I'm glad that he decided to come and join us and moderate through the morning event. Thank you. The floor is yours.
Thank you very much, Uwe, for the kind introduction. Welcome, everybody. In the first block of today's conference, exploring the EU-Russia-related sanctions, we have four fantastic and highly experienced speakers from different backgrounds who will in many ways allow us to take a critical look at the extent to which EU sanctions and the procedural mechanisms underlying it in their current shape are consistent, transparent, and in compliance with the rule of law, and if not, or if to an insufficient degree, how the current mechanisms could be improved with a view to increase the implementation and effectiveness of necessary economic and financial sanctions while ensuring the respect of basic principles of the rule of law. So without much additional words from my side, because you want to hear from our speakers, let me introduce the first one, Dr. Anna Oehmichen, a valued colleague from Berlin, who is the author, together with her colleague Salomé Lemasson, of the study, Russia Invasion of Ukraine, Are EU Sanctions Going Too Far? A Critical Assessment. I've had myself the pleasure to collaborate on a sanctions matter related to the sanctions imposed against the Democratic Republic of the Congo with Dr. Oehmichen. So I'm very much looking forward to your presentation of what I think is a very insightful study. So Dr. Oehmichen is a criminal lawyer and academic based in Berlin, heading her own law firm, specialized and experienced in cross-border criminal defense and white-collar cases in all aspects. Besides her practice, Anna also holds a lectureship in European criminal law at the Justus Liebig University of Gießen and regularly publishes in criminal law matters. Is therefore also a very valued member of the academic community. Anna, we're looking forward to your presentation. Thank you very much.
Well, thank you very much for the kind introduction. And thank you very much, Uwe, for taking the initiative for this whole conference, which I think was a very brave and timely idea and very thrilling and I think important at this time, especially. And also thank you to NAΗMA Strategic Legal Services, of course, as you were, as they are organizing this conference. Another person I really have to thank you wholeheartedly very much is Salomé Lemasson. You heard the name already a few times today. And she's a dear French colleague of mine, also based in Berlin. And we collaborate in cases together, sanctions-related cases. And she's a full expert in this field and also a dear friend. And I very much regret that she cannot be here today, but she has a very good excuse. She gave birth less than 1 month ago. And so I think she has a good reason not to be here today, but you must also imagine that now this expertise has been written by her and me, but by her in full pregnancy. So that deserves another respect. Yeah, so I have to present our expertise alone, but if you need to get in touch with her, let me know, and I'm happy to put you in contact with her as well. One thing that Uwe already pointed out, I also want to stress once more, in order to avoid misunderstanding, the expertise does not follow the purpose to say that sanctions are bad or that we want to lift all sanctions, but the purpose is rather to provide a critical assessment of them in order to make them work better in the future. So like constructive critique. I will start with an introduction into the topic and then highlight some selected issues. And these are going to be just one of the few of them because of the limited of time, not all that we have explored in the expertise. One will be the lack of legal certainty of some of the provisions. One will be the prohibition of legal services and the rule of law. One will be the discrimination based on nationality that is evident in a few provisions, and one question of the criminal nature of sanctions. And I will conclude with our findings. So, restrictive economic measures or sanctions have always been used or often used as an economic tool in response to military conflicts in foreign policy. This is nothing new. In the 17th century, there were the Navigation Acts in the UK that allowed only ships sailing under its own flag to transport certain goods. They aimed at diminishing the Dutch seafaring. In the 19th century, there was the Berlin Decree of Napoleon, which meant to block all ports for the entry of British ships and goods as a response to the blockade instituted by the Royal Army upon the British order in Council of 16 May 1806. Then in World War I, Britain blocked the Northern Sea in Germany in order to avoid goods enter German ports and in order to avoid German warships from leaving Germany and entering the ocean. Then in the Cold War, there was a coordinating committee for multilateral export controls, or COCOM, that started to control export of technology to states of the Eastern Bloc. And now the first sanction against Russia that we identified was already back in 1982, when the European Economic Communities restricted the import. And the political background was the Polish declaration of a state of war in order to eliminate Solidarnosc which was the first independent and democratic trade union. So in a nutshell, we see, and then, then subsequent restrictive measures were passed in the European Economic Communities and later also in the European Union in the framework of the Common Foreign and Security Policy, as well as at a UN level regarding either certain themes, so-called thematic sanctions like on dual use, torture, terrorism, chemical weapons, or geographically regarding Syria, Belarus, Iran, etc. The types of sanctions were very various and have been various since then. So we have arms embargoes, we have financial restrictions, we have asset freezes, travel bans, and also many other sectoral targeted economic measures such as import restrictions, export restrictions, provisions of services, bans on provision of technical assistance, etc. From all that, we see that sanctions are potentially efficient. They do send a clear foreign policy sign of disapproval, while being more moderate than a full embargo and less dangerous than a military deployment. Now, with the invasion in Ukraine, 10 sanctions packages have been adopted, and they have been adopted in an unprecedented speed. Since autumn last year, criticism from lawyers increased regarding the sanctions. There has been a complaint before the European Court of Justice, and there has been this open letter. But once more, to be clear, this legal opinion does not dispute the importance and the need of the sanctions, nor does it request them to be lifted, but we require a critical assessment of their impact, quality, and feasibility, as this will be needed in order to have them overall accepted, and their acceptance, it will depend on their acceptance, how well they work in practice as well. Coming now to the first issue, the legal certainty. The problem with several of the regulations and provisions is a very broad and vague terminology. We observe that in EU regulations, in EU legislation in general, because it's always the result of a compromise between countries, obviously. But in this case, based on the impact it has, it's quite problematic if they're so vague. So one example is Article 5AA speaks of engaging in transactions, but it doesn't define what transactions. In Article 5N, they talk about indirect provision of services. How far do you have to go to trace whether the services you provide are indirect? In order to make sure that not ultimately at some point they do benefit a Russian company. And then in the regulation 269/2014, the criteria that are needed in order to put somebody on these lists, the so-called sanctions lists, is if the person is responsible for supporting or implementing actions or policies which undermine or threaten the territorial integrity, sovereignty, and independence of Ukraine, or stability or security in Ukraine, or which obstruct the work of international organizations in Ukraine. Obstructing the work. If you require a lot of paperwork from an international organization, are you already obstructing their work? It's very, very vague. And maybe one of the most problematic terms is the so-called association clause. Not only the persons that are on the list for as I said, supporting or implementing actions or policies which undermine or threaten the territorial integrity, etc., but also persons who are just associated with these persons are listed and sanctioned. And until the 8th of March, there was not much legal guidance. What does association mean? And only then the European Court of Justice fortunately clarified that being a family member is not sufficient to be associated in that sense. And the other problem is, I mean, sometimes you have vague terminology in law, but then you have case law that helps you interpreting it. And in the case of the sanctions, we have very few resources to help interpreting the sanctions and these vague terms. We have the council decisions that are the foundation for the regulation, but they often do not divert much from the wording of the regulation itself, so they do not give additional guidance. We have the recitals, and maybe probably the most important source to help interpreting are the frequently asked questions published by the Commission, but which do not have necessarily legally binding value, and which are currently updated, but which are not updated at the same speed as the sanctions are adopted, obviously. So every time you have a new sanction, there's no frequently asked questions answer to how to interpret this new sanction. And it always takes at least a few weeks to get the sanctions in the very moment of their coming into effect. Other sources are EU primary and secondary law, especially regarding certain definitions. This may be helpful, but then with regards to case law, we have, as I said, very, very little, and also academic writing is scarce in that area of the new sanctions, especially. I now come to another issue, which is the prohibition of legal services. I think others of you we will hear more lawyers talking about that today, maybe. So I just want to give an introduction. It has been passed with the 8th sanctions package in October last year, in Article 5N, paragraph 2. And under that provision, it shall be prohibited to provide directly or indirectly certain services, including legal advisory services to A, the government of Russia, or B, legal persons, entities, or bodies established in Russia. That means that it includes both direct and indirect services. It is limited to the services to legal persons, so not natural persons, fortunately. Circumventions are also prohibited under Article 12. And it is limited to advisory services as opposed to non-contentious matters. And there are relevant exceptions for the services that the ban on legal services does not apply if it's strictly necessary for the exercise of the right of defense in judicial proceedings and the right to an effective legal remedy. But this, again, is subject to interpretation. When is defense strictly necessary? Do you need an investigation already having started in order to say now it's necessary, or is it already necessary preventively before that moment? Then another exception is that when it's strictly necessary to ensure access to judicial, administrative, or arbitral proceedings in a member state, as well as for the recognition or enforcement of a judgment or an arbitration award rendered in a member state. Again, access to proceedings is only the contentious matter and not the advising beforehand. And finally, another exception is if it's intended for the exclusive use of, and I will abbreviate it, legal persons established in Russia but effectively controlled by EU entities. So then again, it's allowed. And to finalize just the description of this ban, there is, like in many prohibitions in the sanctions, a possibility where competent authorities may exceptionally grant authorization and derogate from the prohibition. But this is only under such conditions as they deem appropriate. After having determined that this is necessary for, and then comes a long list of things like humanitarian purposes, civil society activities, functioning of diplomatic and consular representations, ensuring critical energy supply within the Union, etc. Now, the problems, the most obvious problems that we as lawyers identify is that the distinction between contentious and non-contentious, or advisory and contentious services, is impossible to make as a lawyer, because you don't want to wait until investigations have been opened before you start advising your client. You don't want to wait. You don't want a client to say, I want to sue them, without advising them before. Is it necessary? Do you need it? Is it better? Is there a way to avoid litigation? So you need to have this preceding advisory step as a good lawyer, also to in the best interest of your client, and also to avoid unnecessary proceedings, and especially to avoid the violation of sanctions. And this is the more true looking at the vagueness of many of the terms and the difficulty in navigating through the sanction system, which require legal advice. It's very difficult for certain persons to comply with the sanctions, also companies, especially companies, because they are subject to this prohibition of legal services without consulting lawyers. And then I mentioned it already, what is strictly necessary to exercise a right to defense in judicial proceedings? So this ban on legal services may have provoked many lawyers from withdrawing their mandates and stopping to consulting people, because they're just afraid they're violating the sanctions now if they continue supporting their clients. Obviously, that is also the purpose of the sanctions, but the question is this still in the framework of the rule of law to deny access to law, to legal advice? And finally, under which conditions do authorities deem a derogation appropriate? There's no case law, because these decisions are not published. So the only way of knowing will the authorities grant an authorization or not is by trying, try and error. And authorities are, of course, afraid of granting such authorizations, independent of what the legal situation is. So, in a nutshell, this prohibition of legal services conflicts with the fundamental right of access to a lawyer in Article 47 of the Fundamental Rights Charter. And Salomé and me defend the view that the access to legal advice cannot be dependent on the authorization by an authority, and the prohibition shows a general distrust against the legal profession as such, although we as lawyers are an integral part for the preservation of the rule of law and justice being properly rendered. This is a development, by the way, that you also see in other areas of law currently at the European level, especially with regards to the facilitators in tax law, and also with regards to money laundering and the reporting duties upon lawyers. Okay, I come to the third issue, and that is discrimination based on nationality, and that is for me as a German particularly worrisome. that some of the restrictions are really based on the sole criterion of nationality. And I just give you the examples that are in Article 5b, the prohibition of Regulation 833, 2014, the prohibition to accept any deposit from Russian nationals or natural persons residing in Russia, legal persons, entities, or bodies established in Russia, or to provide crypto asset wallets, account, or custody services to them. So there's really no other criterion than that it comes from Russian nationals. Another example is the obligation for credit institutions to supply to national competent authorities a list of deposits exceeding 100,000 euro held by Russian nationals. Article 5G of Regulation 833. And the last one, prohibition to provide registered office, business, or administrative address, as well as management services to a trust or any similar legal arrangement having a trustor or beneficiary Russian, having as a trustor. So if the trustor or beneficiary is Russian national, then this is also prohibited. There I forgot to mention the provision, but if someone is interested, I can tell you later. So this discrimination obviously conflicts with the equality before the law, which is established not only in Article 20 of the Fundamental Rights Charter of the European Union, but also in the preamble, in the very preamble. And it conflicts with Article 21 and Article 14 of the European Convention of Human Rights, the principle of non-discrimination. Using nationality as a standalone criterion is a dangerous and slippery slope that jeopardizes the very existence of the rule of law. And remembering Europe's darkest hours, combined with the emergence of more populist and nationalist parties throughout Europe, look at Italy, economic sanctions should not be enacted to the detriment of EU core values like the rule of law, equality, and justice. And I come to the last issue that I will tackle today, and that is the question whether some of the sanctions are not actually criminal in nature. Because some of these administrative, so-called administrative sanctions, for instance, the freezing of assets, have similar effects on individuals as criminal penalties, actually. Under the autonomous notion of criminal of the European Court of Human Rights, in the context of their case law on Article 6 of the European Convention of Human Rights, there are three criteria to be complied to qualify a measure as criminal. One is the legal qualification of the offense under domestic law. One is the main criterion, that's actually the main criterion, the very nature of the offense. And the third one is the degree of severity of the penalty incurred. Well, with regards to these personal-related sanctions, the legal qualification of the offense under domestic law obviously is not criminal, it's administrative. However, what is the very nature of the offense? And there it becomes difficult to judge. There are a number of sub-criterions to qualify whether they fulfill that requirement, and we don't have the time to go in depth, but just to give you a broad view on it, the European Court qualified several administrative offenses actually as criminal offenses. But on the other hand, the European Court qualified political measures very often not as criminal. For instance, electoral sanctions or impeachment was not qualified as criminal. So in that sense, it's difficult to foresee how the European Court would qualify these measures if it was asked for that. But the third third criterion, the degree of severity, definitely satisfies the criterion, because freezing of all bank accounts and giving no access to economic funds for an indefinite time period, because the time period is until the war is over. How do we know when that will be? And how can the person sanctioned influence that? So it's not a provisional measure like the freezing of assets within criminal procedures before the conviction, but it's a measure that is not limited in that sense, and therefore very well comparable with a heavy criminal fine. From this, I conclude that it is thinkable, though rather unlikely, that the European Court of Human Rights might qualify a sanction as criminal. And if that would be the case, then a full criminal trial would be required before someone could be put on the sanction. The person would need to be informed about their charges and have the right to be heard before the sanction can actually be enforced. The proportionality had to be observed. So depending on what exactly is the allegation of the person, how close is the linkage to or the influence that person supposedly has, would depend the size of the scope of the sanction, how much money may be frozen, etc. However, the conduct described in the sanction, the then qualified criminal conduct, supported or implemented actions or policies which undermine or threaten the territorial integrity, sovereignty, and independence of Ukraine is, of course, way too vague to satisfy the requirements of accessibility and foreseeability of the law as required under the nulla poena principle in Article 7. I didn't. Battery is over. No, it's not. I pushed the wrong button. It's okay. Yeah, nulla poena. So, but even if the European Court will not qualify it as criminal, which I said is probably more likely due to its political nature, there are still some minimum procedural standards that should be met, such as there should not be listings on the sole ground of the nationality. There should not be listings on the sole ground of family bounds to a designated person. Or association cannot be assumed on the sole ground. There needs to be a minimum of corroborated factual evidence for the alleged influence, assistance of the designated person. And the concerned person needs to be informed individually and directly, and not only by applying the sanction and publishing it in some annex to some EU regulation. I could understand that the person doesn't have to be informed before the sanction is applied, because then they would save their money somewhere else before it can be frozen. But after the sanction has been implemented, they should be informed directly. And the principle of proportionality should also apply in administrative law and also to these administrative sanctions. And this means in particular that the material scope of the sanction and the time period for which it is adopted should be definite under proportionality aspects. And also another consequence of the principle of proportionality is that the standard of proof to uphold the measure needs to become stronger the longer the measure lasts. That's the same in the case law of the German Constitutional Court with regards to pretrial detention. In the beginning, you need just a strong suspicion to have somebody detained, but the longer he is under detention, the higher the standards that need to be proven in order to still justify the detention. And this, in my view, applies similarly to money asset freezing measures. Not in the same extent, because the impact on the fundamental rights is not the same, but proportionally. And finally, you need adequate legal remedies against the sanctions, and that's a topic that one of our next speakers will also go into in more depth. I conclude with our findings. So one is that we need minimum procedural standards as just being presented. And based on the outlined shortcomings of the speedily adopted legislations, we're of the opinion that the sanctions should be regularly reviewed and streamlined to ensure consistency and adequacy. It would be good to have additional guidance in form of specific training on how to apply the sanctions and how they are actually implemented in practice and how they are being enforced in the different member states. And it would be very useful to have, like we have that with other EU instruments, an implementation report. And ideally, that should include a compilation of national decisions and case law, so that people have more guidance on how they are being implemented and how they are being applied in practice and how to advise the clients. Okay. If you have any questions, ideas, you're welcome to raise them now or later via email also. And I thank you very much for your attention.
Thank you very much, Anna, indeed, for this thought-provoking presentation and for explaining the approach that you took in your study and for highlighting its key findings. We started a bit late, but I think we still have about 10 minutes for Q&A on this opening study. Yeah, please join me on these more comfortable chairs. May I open the floor? Any questions from the audience? Comments to the author of one of the co-authors of the study? Yes, please, here in the first row. Oh, maybe.
Thank you. My name is Yuri Shumilov. I'm a partner at Aki. The question I had is, why do you think so far no challenge has been done to the sectoral sanctions based on their discriminatory nature? Why no Russian appeared who would challenge the restrictions, the ones you talked about on deposits or whatever, or the bank accounts? Why there's been no challenges? What's your view on that?
To be honest, I don't know if there have been any challenges. I mean, there haven't been any that have become public, because those are bans that you have to fight at national level usually first. And maybe I was thinking myself when I was looking at the presentation that it has been maybe a bit unclear. We have to differentiate between the sanctions under Regulation 269, 2014, which really have as an annex a list of persons that are subject to these sanctions and that are subject to travel bans and the freezing of assets, and these are not based on the sole criterion of nationality. And we have the other economic sanctions under Regulation 833, 2014, and the discrimination provisions I cited are all based on that provision. So there it is in the course of how far you can go with interacting with Russian nationals, whether there it's based on the sole criterion of nationality. So probably the persons concerned of these sanctions are the persons who are impeded from interacting with the Russian nationals, and not the Russian nationals themselves who can challenge it directly.
I think it's easier with a microphone for those participants.
No, I just wanted to contribute a small thought to your interesting question. I have the impression that indeed there is a complete reluctance of Russian state-owned structures, not Russian individuals, but in accordance to your point with the 833 and 269, they out of policy reasons, and we have a quite a lot of cases in which this is exactly the discussion. Out of policy reasons, they don't want to make themselves dependent on enemy jurisdiction, so to say. And I think this is a top-down decision. So the big state companies and the state itself will not go to Luxembourg. They just don't go. And honestly speaking, I understand it. I understood it ex ante. Now we see the code shifting so a little bit. There are different chances for completely illegal stuff now, but there is this kind of so your question, I think, as far as it concerns state structure, the state-owned companies of Russian Federation, it's a clear political decision in my view. They just will not.
Thank you. This is a good point. But what I'm wondering is how come there is no just some Russian, right? Some, I don't know, some guy who weren't able to, I don't know, has his account blocked or something like that, and no one. I mean, purely he could. Well, surely he could have run the argument that he's prevented from having money in the account purely by reason of nationality, and yet at least I'm not aware of any such cases for some reason. No, 833. I mean 833. I mean 833. That's the 269 for sure. But I'm wondering why they're not doing 833. Or at least if anyone is aware. I think.
Just give a reply to the last question. Why nobody is attacking 833, Regulation 833 from 2014? It is because the possibilities of control, of legal control of the court are limited in Article 275. Only insofar as a measure concerns an individual, the court is empowered to take a decision. And 833, as a matter of fact, has no direct victims. It is a general provision, while Article 3 of Regulation 269 from 2014 has an annex where all so-called oligarchs are listed. So there, according to Article 275 TFEU, in particular, second paragraph, that can be attacked. But otherwise, and there's another actually scandalous aspect, the Court of Justice is not entitled to revise, control, or annul measures adopted in the framework on the common security and for foreign and security policy. So that is the reason for not attacking 833.
Thank you.
There was another question here.
Dominique Geyser will be talking later on, but indeed that was the answer. And to understand things very concretely, somebody who is listed is allowed to introduce an annulment procedure against the fact that he is listed, because the reasons for which he has been listed are, according to him, not relevant. He is not entitled, in general terms, to discuss the decision itself, the regulation in itself, because it's of a general nature. So it is just impossible. That's the reason why you don't have those cases.
Do we have any further comments or questions to our first speaker?
So I'm Carsten Zatchler, and I'm an Irish barrister. And I was interested by the question of qualification of sanctions as criminal, quasi-criminal, and your rather pessimistic approach. And I was just wondering whether that doesn't depend on the anterior question in a way. Qualification as criminal for what purposes? And I'm thinking here about not going necessarily as far as requiring a full criminal trial and that sort of thing, but merely the question of triggering other procedural guarantees under Article 6 ECHR or Article 47 of the Charter. In terms of qualifying them as quasi-criminal sanctions, in the same way as maybe competition fines have been qualified in Menarini case law, the lifts cartels and so on, by the European courts as quasi-criminal, therefore at least triggering some of the guarantees of Article 47 of the Charter than Article 6.
Good idea. I'll think about that. Yeah.
And I think the gentleman at the back first, and then I think you can take those two additional questions. You want to go first? Yeah. Oh, sorry. We were just okay. Okay. I misunderstood that as a. Then here we go.
I was going to talk about Jean-Paul anyway, so. Hi, I'm William Julier. Just a quick comment, but I don't know if someone is going to speak about the legal ban or not today on legal service, the ban on legal service, because I know Jean-Paul was maybe going to say something. Are you speaking, Jean-Paul, on the... yeah, just maybe a quick comment on that, because Jean-Paul drafted the application, so I think that he's the one who must maybe say something about it. But the idea is an idea that we had together at the beginning of our common fight last year. And what is, maybe he can have a word about the content, but about how this emerged. It's interesting to see that in the first place, this application was filed in by a French lawyers association called l'ACE, l'Association des Avocats Conseil d'Entreprise, which is a corporate lawyers association. So nothing to do with sanctions, nothing to do with criminal law, more to do with business and business law. But this is the only place where we found some echo to what was our surprise when we read this ban. And with Jean-Paul, we were saying, but I mean, this is unprecedented, maybe since World War II, where some people, some lawyers were banned from doing their job as lawyers because of their religion, culture, and things of that kind. And I felt that this was unprecedented. So I reached out to the Paris bar. And I know that Jean-Paul spoke to the Belgium bar, Brussels bar. And that was early, maybe summer last year, something like that. And we didn't get any official response, but the response was a kind of no response. And nobody was kind of thinking that we needed to say something or move. So we got that started with the ACE. And then, not suddenly, but once that was on the move, the bars started to be a bit more interested. They didn't voice much out, but they did gather in at the end of the day. And the Paris bar voted an application too. And I think the Brussels bar did also. And I think that now maybe the Geneva bar is also on the move or did something. But it was interesting to see how long it took, and that the official representatives of some important EU bars did not at the beginning respond at all to this ban, which, as I said, is unprecedented. And I got to that because I happened to be working before the war with some Russian firms and providing advice on some corporate questions. And that's very interesting, Anna, what you brought to the table, which is, when are you in the scope of the rights of defense? If a Russian colleague asks me to deliver an advice on an extradition matter or on the risk of an extradition case to get started against a client, I cannot deliver this advice to this colleague who is a colleague. He's not a supporter of anything. He's just a Russian colleague. And I can't give him any advice would he ask me for a client who could be non-Russian, actually. Let's say they are advising a Danish client or a company based in, I don't know where in the world. Okay, they are interested to set up a company in France. Could you tell us how you do that? I can't do that, which is unbelievable. And we'll see what the court says and whether they consider that regarding primary law, there is a question here which is serious enough for them to come out with a legally based decision. Maybe Jean-Paul, you can have a word on that.
Hello, everyone. Sorry that I bumped like that in the conference, but I'm just out of a hearing at the Palais de Justice, just a couple of blocks away, and that now we'll have to get back in the afternoon. And I was replying just on my cell phone a couple of minutes ago. That's the way lawyers have to manage their time. So, as William just said, with regard to the litigation with regard to sanctions, we are facing an incredibly violent situation that we never had before. I have 42 years of practice behind of me. I plead regularly before the General Court and the Court of Justice. I never had examples like that, in which the EU institution is doing and playing, I have to say that, very, very dirty tricks. And what William just highlighted, the fact that a regulation dated 6 December 2022 prohibits lawyers to provide services to entities established on the territory of the Russian Federation, that is unprecedented. You cannot find any example like that in the history of EU law. It's totally in breach of a lot of major and fundamental principle of EU law. And given the fact that I spend quite a few times in the corridors of the Commission every week, now for years, I've been told that the next packet, the 10th, the 12th, the 14th, we will see that, they are about to prohibit also advising within litigation. That's the next step. And if that occurs, I have no crystal ball. Will that occur or not? I have no idea. But if that occurs, that will be clearly the bridge too far, because what are we going to do with the pending cases? What are we going to do if the Council is extending and postponing for an extra 6 months period of time, let's say in next September, because there are a lot of arguments to say that that's what will happen, probably, and how the profession will react. You've been told that the Paris bar reacted properly, the Brussels bar also. A union that I represent of about 1,000 lawyers in France was the first to file an application for annulment of that incredible regulation. The Geneva bar decided to intervene voluntarily. But how is it possible that only 4 legal entities are reacting? And the CCBA is just completely silent. How is that possible? And I've been told that there was a discussion about that in the late weeks, and it was decided not to act. So that's the current situation. And I will not get going into details of cases, nothing to do with the regulation, but when you defend natural person listed, it is incredible, because the case law, we will probably browse that in the course of this conference today, but how is it possible the Council is not communicating proper files with strong evidence? Just a couple of extracts of website from anonymous bloggers, and that's it. And if you browse to the motivation, you will see completely general concept. Most of them are not legal concepts. What is an influent businessman? What is a major shareholder? I know majority shareholders, I know minority shareholders, I have no clue about what is a major shareholder. And I can continue with a lot of concepts like that. So it is a very difficult time for lawyers, clearly. And you know the administrative procedure with regard to the reconsideration effects. No answer before the very late day before the final validity of the sanctions. Just no answer. And if you highlight the fact that everyone should be using its right to be heard, which is granted by the Charter of the Fundamental Rights, they say, well, you produce a couple of documents, that's all. The right to be heard is to be considered completely the same way that just filing a memorandum. If you look now to the authors that are commenting Article 42 on the right of to be heard, nothing like that is highlighted. But it's fair to say that in the rulings of the General Court, you have a couple of examples accepting the fact that you are considered to be heard if you file just 3-page observation. Is that the balance between the parties which is acceptable? Is that the right of defense that is to be guaranteed? I have some doubts with that. So again, thank you definitely for the organizer to have the courage to put this subject on the table, because there is a very need for clarification in all those matters. Thank you for that.
Thank you very much for these insightful comments. I'm very mindful of the time because we're 20 minutes behind the scheduled program, and we want to hear also from our other speakers. I would suggest, since we're still early during the day, we can continue what is certainly a very intense debate over the coffee break and lunch. And I would suggest we move on, with your permission, to the next speaker, who is Nikolai Petrov. Nikolai is an independent researcher focused on Russian domestic politics and the impact on foreign policy, on political regime in Russia, elites and decision-making. Early in his career, from 1990 to 1995, he served as an advisor to the Russian parliament, government and presidential administration. He's currently a guest scholar at the German Institute for International and Security Affairs, Stiftung Wissenschaft und Politik in Berlin. From 2013 to 21, he was a professor and head at Laboratory for Regional Development Assessment Methods at Higher School of Economics in Moscow. He's a member of scientific boards of the Journal of Power Institutions in Post-Soviet Societies, Russian Politics, and Russian Politics and Law, to highlight just some elements of his very prestigious CV. And the title of Nikolai's presentation today is Criteria for Landing on the Sanctions List. Are all oligarchs equal? Nikolai, the floor is yours. Thank you.
I'd like to thank organizers not only for having me, not a lawyer, here, but also for taking this very important initiative. I'll try to approach the problem from a different point of view, and thanks to Anna, it's possible for me just to add the view from the political science and from the point of view of Russian domestic politics. I myself somehow under sanctions, not only Russian sanctions imposed on me as on the foreign agent, but also somehow Western sanctions because I am Russian national. And I do feel not that well. Of course, it cannot be compared to those who are in the list of personal sanctions. But anyway, now in a year after sanctions have been imposed, it's possible and it's needed to look at how they do look and how they do work. And I would see three real problems with this. One connected with the presumption of guilt forever, which looked not that surprising a year ago when it was needed to react immediately, but I think which cannot be kept
for long. Then there is absence of differentiation when all rich persons, and I was asked to speak about so-called oligarchs, are put into this list regardless of how and even when exactly they got their wealth. And the third one, the absence of a way out, irreversibility of those sanctions imposed. So my first point is connected with the fact that the very term oligarch regarding present-day Russia is misleading. There are no oligarchs in Russia now. There are no persons who, due to their wealth, can play any independent or even semi-independent role shaping decisions and influencing Russia's policy. Russia is centralized authoritarian state, which is different from Ukraine. In Ukraine, before the war, we did have oligarchs, and Ukraine that time used to be competitive authoritarian state where different oligarchs could compete for their influence. In Russia, it's not the case, and it was clearly seen recently when several days ago President Putin did speak to the Union of Russian Industrialists and Entrepreneurs, which used to be called the Trade Union of Russian Oligarchs. And he was celebrating his victory. He was telling them, hi guys, I was telling you all the time that you are treated and you will be treated all the time at the West as persons of the second grade. And now you should come back to Mother Russia. You should invest into Russia, and you should your money, let working on Russian regime and Russian economy. And that's how windfall tax now is offered and will be paid by rich persons in Russia. It's needed to look, and this is my second point, it's needed to look at the evolution of the role of wealthy persons in Russia. In 1996, 1998, there was a pretty brief period when there used to be so-called oligarchs as very rich and very powerful persons. Some of them later came to executives, some not. And today, by the way, is 10 years after the death of Boris Berezovsky, pretty mysterious death of Boris Berezovsky, the one who did coin the very term seven bankers rule in Russia, and one of these seven major oligarchs. There is very interesting classification offered by Andrei Yakovlev, a Russian scholar who is in exile now, and who looks at the relative influence, the balance between three major groups in Russian elites: oligarchic business from one side, top federal bureaucracy from other side, and Siloviki as the third major player. In his view, in 1996, 1998, oligarchic business was the major player, while top federal bureaucracy was a junior player, and Siloviki did have limited influence. Now it's vice versa, and starting from 2012, he shows that oligarchic business did play the limited role, while Siloviki are major players and top federal bureaucracy can be considered to be junior players. I would add that in 2022, the situation did change, and since 22, we do not have businessmen as autonomous players at all. They do play very instrumental role. Of course, they are somehow connected to Siloviki, they are somehow connected to the federal bureaucracy. That's why Daniel Treisman, American scholar, did come with the term silovarchs, combining Siloviki with former oligarchs. Only in this case, being directly connected to Siloviki, wealthy persons in Russia can still play important role, but not as independent players, and they cannot lead. They are important sometimes as an instrument for Siloviki to reach their goals. Now I am coming to purposes of sanctions. There are discussed two major purposes. One is to punish those who are somehow contributing to the regime which did start this horrible war in Ukraine. The second purpose is to provide for certain changes, to stop the war in Ukraine and to weaken the regime. In my view, the major driver of personal sanctions, and here the difference is with sectoral sanctions, was a kind of Western leaders' populism, because it's much easier to find targets among so-called wealthy Russian oligarchs, and it's not any kind of double-edged sword. When punishing them, you do not have any negative consequences for yourself, unlike in sectoral sanctions, and you should wait for applause. Wealthy persons are punished, their yachts, their palaces are taken out of their control. But in my view, in case of punishment, it's not very well addressed, and that's why it played very limited role. In case of changing the regime, it did play even counterproductive role in some cases, like in case of German Khan, who used to be Russian former oligarch living in London. And due to sanctions, he being unable not only to live by himself, but to send his children to school, came back to Russia. So instead of weakening the regime, instead of inspiring split in elites, this kind of sanctions can lead to a very opposite result: consolidation of the regime and strengthening, due to the fact that those money which was out of Russia's control now are coming back to Russia. When saying this, I would not like to criticize the move made a little bit more than a year ago. It was understandable that time that something should be done immediately, and it's understandable that there was no time to differ between different kinds of wealthy persons and to understand who should be considered to be more guilty, who is not guilty at all. But now, in a year from this time, and when the situation, the vision of the situation is very different, and I do agree that the war is going on and nobody knows when exactly it will end, meaning that sanctions should be somehow revised, or at least efficiency of sanctions should be analyzed, and if needed, sanctions should become not lifted, but they should become more sophisticated and much better addressed. So now I think it's a good time to look at sanctions, including those I am dealing with against wealthy persons, from this point of view. Present-day sanctions do not give any way out. So if you are a rich person, if you are under sanctions, there are no reasons for you to do something in order to weaken the regime. You are, proclaimed to be a criminal, and proclaimed not by judges, but proclaimed by politicians driven by their own personal or partisan political interests. So far, we do have only two cases when personal sanctions have been lifted. One case is the former governor of Sevastopol, who did come to the court saying that he left from this position long ago and he's no more among top Russian bureaucracy. Another one is mother of semi-oligarch, semi-gangster Evgeny Prigozhin, who did prove that she does not have anything in common with his business. And that's all. Recently, 2 or 3 days ago, my former colleague and good friend of mine, Michael McFall, did offer the way how a kind of the way out can be approached. And in his view, those who are under sanctions now should have the opportunity to make these sanctions easier or to be lifted if and when, first, they would proclaim regime to be the criminal, and they would protest against the war in Ukraine, and B, they would offer part of their wealth, part of their fortune. He speaks about half. It's not that easy to estimate, to restore Ukraine after the war. And in this case, we can discuss whether this works or any other recipe like the one offered by Mikhail Khodorkovsky, the former oligarch who is in exile after serving 10 years in prison. He formulates 3 different conditions, but I think that it's time now to switch from sanctions forever, from sanctions irreversible against rich persons in Russia to sanctions much better addressed. And the main reason is that much more effective. The sanctions which could lead not to consolidation of Putin's regime, but to split in elites and to make the regime weaker. That's why systemic revision, I am not speaking about the need to focus on this or that particular person. Let them go to the court and try to prove that there were sanctions by mistake. But I do have in mind systemic revision of the whole package and even of the whole approach to sanctions in case of personal sanctions. Thank you.
Thank you very much, Nikolai, for your presentation. Are there any questions, comments from the floor, from the audience? Please.
Just 2 sentences. We will have the chance in the afternoon to discuss this more broad. Nikolai, what you said is extremely important also in the legal dimension, because what you correctly describe is the complete lack of proportionality of a lot of measures, because as a consequence, if they are not successful, if it's not possible that they are successful, and if they cannot reach the target, which is proclaimed to be under the foreign policy of the Union, they are illegal, because then they are not proportional, and the proportionality is a crucial element of the legality of sanction. So, I mean, that is very shortcut, and the differentiation makes it much more complex. But as a matter of rule, your argument is crucial also for the legal approach, and this is why we always in our briefs touch these issues. And the opposite effect of sanctions, that sanctions make the oligarchs, so-called oligarchs, come closer to the regime of Putin, is the very truth why they are idiotic, even if you follow the political targets of the system. So, and those sanctions being idiotic, it's a legal, I mean, it's not a legal term to be idiotic, but we call it much more decent lack of proportionality. No? So this is what we have in our legal documents. So your science and our science, they are close together, and we need, at the end of the day, we need to enter your analysis in our briefs. It's legally important. Just wanted to say this.
Do you want to directly react, Nikolai?
Yeah, just a few words. I do completely agree with you, and in my sense, it's extremely important that instead of presumption of guilt, there should be presumption of innocence, and somehow in future it should work. But what is needed now, I think, it's a revision of the very approach, not focused on particular persons, but providing the new vision of the war which can go on for years from now, and which, when reasons should appear for those who can play important role, not necessarily influencing decisions, but contributing their money, should play the opposite role. And that's why I think it's extremely important to understand that somehow those sanctions which do work now are playing counter opposite to the idea which was at the beginning why those sanctions have been imposed.
I have another question. Turning to the topic of your presentation, I take the point that there are no oligarchs in the strict sense of the word now in Russia, but are all oligarchs equal? Right? Can you sort of, if you just take oligarchs as a general term to describe like rich Russian businessmen, is there some criteria you think that can sort of group good ones from the bad ones? I don't know. You mentioned the period when wealth was generated. Do you think that is a criterion? Can you say that those that generated wealth, before are better than ones that generated wealth after Putin came to power? Or do you think there is some other criterion that you could sort of, use to distinguish, good ones from the bad ones?
Thank you so much, Yuri. I can elaborate on this a little bit more, and this is extremely important, I think. Not only it should be a kind of temporal approach when we do see whether the wealth came from a period 20 years ago and the person did not commit any crimes, or it's result of cooperation with Putin's regime. And here I can say that so-called oligarchs, it's easy to use this word, although there are no oligarchs at all, they can be divided onto Yeltsin time oligarchs. Almost all of them are over, not only Berezovsky, who is killed, but Khodorkovsky, who is in London, but no more. He is a kind of influential in Russian politics and so on. There are Yeltsin, Putin's oligarchs, those who made their fortune at the time of Yeltsin, but still continue to cooperate with Putin and still continue to earn their money out of this cooperation and exploiting closedness to political regime. And there are so-called Putin's oligarchs. And this is the most important group because many of them are under radars. Unlike those who got their fortune long ago, they are not mentioned sometimes by Forbes because you cannot estimate exactly how wealthy Igor Sechin is. So this is the major Putin's silavarch or oligarch who runs Rosneft company, but whose individual fortune is absolutely unknown. So he runs half of the country, but nevertheless, he is considered to be only a pure bureaucrat. And this is extremely important because how exactly the list of sanctions was compiled? It was easy to go to Forbes. It was easy to look at top 100 richest persons in Russia and to say that, okay, if you are more than $1 billion, you are oligarch and you should be punished. But many of these guys are not in this list, or their fortune is very underestimated. And there is another difference between so-called white oligarchs and black oligarchs. This division appeared in at the end of 2000s when there was the switch from Putin to the tandem. And the reason why there was this differentiation was that some rich persons did have official companies, official wealth. some others, and this is about Putin's oligarchs, who officially control less than a quarter of oligarchic wealth in Russia. They did control financial flows. So if you are selling oil, or if you are, intermediary, you can enrich yourself in many different ways without having the company which is listed and which can be estimated as the essence of your wealth. That's why it's extremely important as well, not only to differ between when exactly the person. Well, now let's look at explanations which is given when this or that person was included into the list. Sometimes it refers to cooperation with the regime which took place 20 years ago. And so we should not consider Russian business as a criminal one, regardless when and how this wealth was made by rich persons. At least initially, if it's proven that the person did commit crimes and due to these crimes became rich, it's another matter. But I would first of all exclude those who do not play. There is no old money in Russia due to understandable reason. If at the West we do have robber barons as great 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 grandfathers of those who are rich now. In Russia, it's combined in one and the same person. They used to be robber barons 20, 30 years ago. They came out of business sometimes. They do not have any companies in Russia. Why should they be considered to be guilty in what Putin's regime is doing? Because Putin's regime was not considered to be the criminal one by the West before the beginning of this war in general, or at least before its latest years, before 2014.
Yes, just one comment on the word oligarch. Maybe you could have a quick definition of what an oligarch is or not. But what seems to me also important maybe to touch upon is that this word is not a legal category. It is maybe a political question, sociological question, historical question, extremely important and interesting one. But I think that maybe some of our problems and maybe some of the problems that relate to these listings are that there's too much oligarch atmosphere in there and not enough legal category duda. Because, I mean, we're interested in what is a leading business person? How is that leading business person leading? How or how not is he connected with a government, an authority? These are different concepts. Must he be supported by? What are the links that need to be proven or not? These are categories difficult enough to grasp when we're trying to stay within the legal field. But when we go on to oligarch category, it becomes completely impossible to deal with because we've got, I mean, no idea who gets in, who gets out. And my feeling is that there's maybe way too much dealing with this kind of broad, maybe a bit fantasy connected category, and that should maybe not be the case when we're dealing with legal discussions.
Thank you. I would completely agree with you. In political science sense, oligarch is a person who enjoys serious political power due to being wealthy. So initially you are a wealthy person, and that's why you can influence political decision making. And this is once again about the different nature of oligarchs at the time of Yeltsin and at the time of Putin. In case of Yeltsin, we did have a bunch of rich persons who could enjoy their wealth in order to get certain political stakes. Like they did contribute to Yeltsin's re-election in 1996, and they got something in exchange, like control over major Soviet time companies. At the time of Putin, it's opposite. Those who do enjoy certain political power, being directly connected to Putin, are becoming wealthy, are becoming rich. Their wealth is not that public, not on the surface, like in case of Igor Sechin, but in this case, it worked in an opposite direction. You are influential in political sense, you are becoming, like Putin perhaps himself, you are becoming a very wealthy person. And this is another criteria which can be used in order to differentiate between those who should be punished more and those who should be punished less. But the most important person is that under a strong and very centralized authoritarian regime, there are no independent players at all, being them bureaucrats, being them businessmen, whoever. The problem is that all of them, except for the one person, the leader, can play very important instrumental role. And here is another set of criteria. So if you are important bureaucrat, like say governor of certain region or head of the state company, you should be considered to be very important part of the criminal regime. If not, if you are staying aside, not to speak about staying outside of Russia, you should be not considered to be part of this regime because you cannot enjoy any influence being not integral part of the whole centralized authoritarian political machinery.
Today for you in Russia to be wealthy and independent, politically speaking?
There were few cases when it was possible to sell assets to get certain money and thus to be more or less independent. If only you are staying in Russia or even outside Russia, but you do have assets like in business in Russia, you can never be independent because all the time pressure can be put onto your business, you can lose your business, and this makes you very dependent.
So the answer is kind of no, you can't be really independent if you have assets in the country.
Yes, if your business assets are located in the country, regardless of where you live yourself, you are very dependent.
So how do you then, just turning back to my original question, how do you then determine good oligarchs from bad oligarchs? Because yes, some oligarchs have acquired their wealth before 2000, yeah, but they haven't got much poorer since then, right? They still had their factories, plants, and whatever in Russia, and it still operated and still sort of worked very well and earned them a lot of money since 2000 as well. So why would even those original oligarchs from before 2000? So would you say that these people will also have to be regarded as kind of dependent on the regime?
Yes, right. And here I see how this machine can work. So if the West is saying these rich persons that until you do have assets in Russia and your business is located in Russia, which makes you absolutely vulnerable, you cannot enjoy easy sanctions or lack of sanctions. So you should go out of Russia. And here, this is how it can work. Like now, Mikhail Friedman and Piotr Ravin are selling their shares in Alpha Bank. So they do have now, in my view, only small portion of their business interests located in Russia, and they would like to sell this small portion, which will make them absolutely independent from Putin and the political regime. And in other cases, it's impossible to be independent. But this is how sanctions should work. So if you would not like to live under sanctions, please leave your business in Russia, sell it for cheap, sell it for free. And in this case, you can claim for being not sanctioned.
Thank you. I think we have time for one final common question by Anna Oehmichen and potentially one last reaction to that by Nikolai.
Thank you. I understood that the definition of oligarch, if there is one, is also related to a regime. Does that regime need to be characterized in a certain way? Because somebody told me once when we were discussing these sanctions, Trump is an oligarch, and obviously, apparently, only Russians can be oligarchs. So, what would you say? Would you say if the term under that definition, there are also oligarchs from other countries?
Yes, absolutely. In case of democracy, the influence of big money is here, but it's very well restricted. In case of any kind of authoritarian regime, being it Russia, being it Ukraine, being it Kazakhstan, it's a very different case. In case of Ukraine, and here it's very important to understand that there is very serious influence political economic model plays. In case of Ukraine, there is no one particular resource which can be controlled by the state, making all others being dependent from the state, like oil and gas in Russia. In case of Ukraine, there used to be several very influential oligarchs. That's why Ukraine was classified the competitive authoritarian regime. And I would say that, in my view, there still are much weaker, but there still are oligarchs in Ukraine. But there are no oligarchs in Russia. It doesn't mean that Russia is better from political sense. It's different from political sense. And the regime in Russia did manage to control the major source of income. And thus, those who enjoy being parts of this rent redistributing mechanism can be seen as playing instrumental role for keeping this regime afloat.
Thank you very much. Considering that, thank you very much, Nikolai, for this for your insights. Considering that coffee is vitally important in life, and even more so at successful conferences, in particular, that exchanges over coffee are so important. We will not cut the coffee break short, but take the scheduled 20 minutes and resume at 12:15 with the final presentation on this first block. Thank you. Great. Welcome back, everybody, after the coffee break. It is my great pleasure to introduce our next two speakers to you for the final session before the lunch break with the topic Defending Clients Against Sanctions, a Human Rights Perspective. It is our great pleasure to welcome both Maya Lester, King's Counsel, barrister at Brick Court Chambers in London, and Michael O'Kane, senior partner at Peters & Peters in London. Let me say a few more words about our speakers. Maya Lester is a barrister specializing in sanctions law. She represents and advises companies, individuals, and governments before the English and European courts, and has acted in most of the leading cases, including inter alia, CARDI 2 versus Council and Commission, so the leading case on the relationship between UN Security Council resolutions and EU law. Maya has given evidence in 4 parliamentary inquiries on sanctions and spoken at numerous conferences. The legal directors describe her as queen of the sanctions bar without a doubt. That is probably the most beautiful description in the directives that I've personally ever seen. So Maya was a founder of the Human Rights Lawyers Association and undertakes regular pro bono and public interest work. Welcome, Maya. It's a great honor and pleasure to have you with us today. And maybe so you can then just hand over to Michael afterwards. Let me also introduce Michael. Michael O'Kane is a senior partner at Peters & Peters, has acted in many of the most high-profile and sensitive business crime cases of the last 25 years, and before that as a prosecutor. He's the author of a respected textbook on criminal cartels and co-author of the leading resource on sanctions. So at Peters & Peters, he heads the business crime team that specializes in corruption, cartels, extradition, sanctions, investment, fraud, city crime, and compliance. Michael, it's an equal pleasure to have you with us, and the floor is yours. Thank you.
Thank you very much. It's very good to be here. Sorry, excuse the laptop. What I'm going to talk a bit about today is, I know one of the things that this day is focusing on is rule of law issues with targeted sanctions, and I'm going to say something about that. Just first of all, a bit about what I do. So my background in sanctions comes mainly through EU law, but from a UK perspective. So originally doing a lot of delisting cases in Luxembourg in the European Court. But one of the things that I'm able to do as a barrister, rather than somebody who works in a law firm, is that we're not so much worried about conflicts of interest because we're all self-employed individuals. So I do quite a lot of work for the government and government departments, and also for people acting against the government. So I get to have quite a privileged perspective of sometimes the point of view of the institutions and those trying to impose sanctions, and on the other hand, those who are at the sharp end and affected by it. What I wanted really to talk about is to set in a bit of context the current debate about the rule of law and targeted sanctions, where I think there are areas where we do have some real issues. And I think I have a slightly different emphasis from some of the issues raised in the very interesting open letter that I think you're going to be talking about later that some of you here signed up to. And then also a few comments about where the UK has now gone on some of these issues, because obviously one of the results of Brexit has been that we have now broken away and have our own sanctions regimes. And so it's quite interesting to see what the UK has done, partly in response to the context of EU sanctions that I wanted to talk about. So one very obvious point, which is known to all of you, is that the reason we have these lists of people and targeted sanctions was originally an attempt to be fairer and to comply more with the rule of law. There was a sense that the 1980s very comprehensive sanctions regimes imposed by the UN, particularly in relation to Iraq, had been seen as very unfair and as having pretty devastating consequences for the innocent population. So in the 1990s, really at the initiative of the United Nations, who have almost sort of dropped out of the sanctions picture given current politics there, the UN started to talk about how it might be fairer to have lists of those who are really responsible for the conduct that sanctions are trying to target, having restrictive measures imposed on those. Then we had 9/11. When we had 9/11, at the behest of the United States, there was then, as many of you know, an absolute flood of targeted sanctions aimed at terrorists, asset freezing measures. When those were originally imposed, as I said, they were US requests to the United Nations to list people. So you had US and UN lists and then EU lists following those. The process at that time was pretty non-existent. What do I mean by that? So no reason, these were lists of names of people with no reasons given at all as to why they had been chosen for targeting. And the process at the time was described by the then General Counsel to the US Treasury Department as being almost comical. He said, and this has been quoted a lot, we just listed out as many of the usual suspects as we could and said, let's go freeze some of their assets. And that's basically what happened at that time. So when the EU started doing, as a matter of its common foreign and security policy, autonomous EU sanctions, those were then partly sanctions required by UN Security Council resolutions, but then also autonomous EU sanctions, Iran, Libya, the Arab Spring sanctions, Tunisia, Syria, Ukraine, now of course Russia. That's when the European Court started to get interested in due process. And there is very significant case law, really starting from 2006, which is 17 years ago. So there's quite a big body of case law way before the current sort of interest in Russia sanctions about process. And basically what happened from an early case, the first case on all this really was a case about the People's Mujahideen of Iran in 2006. This was before Qadi. And the principles are still basically the same as what the European Court said in the PMOI case 17 years ago. What are the principles? The principles are basically, number one, if you're going to draw up lists of people and companies, you have to give reasons which are not excessively vague, but specific enough that people understand why they're on the list. Second, you have to give rights of defense, which means both knowing the case against you without being just unsupported allegations, but actually some kind of evidence supporting the case against you. And you have to be given an opportunity to comment on that. And there must be some form of effective judicial protection, judicial review. Now, that basic case law then resulted in an absolute flood of litigation in the European Court, mainly because by that point, sanctions on Iran had really ramped up. And from about 2011-12, there were a very large number of listings annulled by the European Court. There were also a lot of cases where listings were upheld, but there were a lot of quite controversial annulments, particularly of cases involving Iranian institutions. That was because a lot of those listings at that time were based on specific conduct that was alleged of those Iranian banks and institutions. For example, the reasons for listing said that they'd been involved in transactions designed to circumvent sanctions or conduct supporting nuclear proliferation. And because the EU had very little, in fact, normally nothing, other than a listing proposal and then reasons for listing, but no evidential support at all, very often the EU didn't have anything to say to support the listing, and they were annulled. But what I think is interesting here is that this created a dynamic between the EU institutions and member states on one hand, and what the court eventually said about the principles on the other hand. And there was quite an interesting dialogue between the institutions and the court. What do I mean by that? Well, the court, having laid down the principles in the PMOI case, in every subsequent case, and this still happens to some extent today, the institutions would argue that those basic standards of the rule of law shouldn't apply in a particular case that happened after that. So in the Cardi case, 17 member states intervened to say you shouldn't apply these PMOI standards of fairness where you are implementing UN listings. Eventually, they succeeded in that view in the General Court, and finally, the case law now is no, same standards apply even when the EU is implementing a UN Security Council resolution, and that is still very controversial as a matter of international law. But then, more significantly for today, the institution said, well, when it comes to sanctions against a country rather than terrorists, you can't apply the same standards. They won at first, and then eventually the court said, no, same standards of fairness, even when we're talking about sanctions because someone is related to the government of Syria or Belarus or whatever it might be. Then they said, well, when we are listing people based on, not on their particular conduct or misconduct, but because they are, for example, a member of the government or associated with, so based on their status, these have become known as status-based sanctions, then the same standards shouldn't apply. Court eventually said, no, same standards apply. Then they argued when it comes to non-state actors, so people who are not listed as members of the government, but nothing to do with the government, or people listed as a member of a category, the same standards shouldn't apply. And again, eventually, but I'm really oversimplifying the story, eventually the same standards were applied across the board. Now, the US became very interested in what was happening in Luxembourg because here's a regional court, not of very much interest to the United States State Department until Cardi and subsequent cases, but they started being very critical, some in the US government and in the EU institutions, of this very activist court that was busy annulling political decisions to put people on sanctions lists. And if you look back at the what was said in those sorts of years when all those annulments were happening, this was a pretty controversial move by the court in Luxembourg, which was really acting more than the court in Strasbourg as a human rights, rule of law focused court. But what the court was not really doing was intervening in the more political side of these cases. In other words, should this person really be on the list anyway? What is this listing doing? Are these targeted sanctions really achieving anything? All that kind of question was regarded as too political and too much for the executive and not for the court. So in response to this flood, what was perceived as a flood of, is this the end of targeted sanctions? What did the EU institutions do? Well, it's quite interesting to think back. They did a number of things which now have become very relevant when it comes to the Russia debate. Firstly, I think at that point, and I'm thinking mainly here of Iran and Syria, there was a bit of a shift away from targeted sanctions. So when you look at how Iranian sanctions were ramped up pre-JCPOA, and when Syria sanctions were ramped up, they really went for the non-targeted sanctions, which is actually most of what sanctions law now is, all those restrictions on transactions and the kind of trade and export control that can go on, which doesn't just affect the people on the list, but affects everyone. And that is not an area where the courts really get involved other than on, the odd preliminary reference case to the European Court of Justice, but that's pretty rare. And so from an institution's perspective, that is a much easier legal way forward to just move. So ironic in a way that having gone with targeted sanctions as a way to move away from comprehensive sanctions, targeted sanctions, because they create fundamental rights for those on the lists, are just harder legally to sustain. So let's go a bit more with less targeted sanctions. Secondly, and really importantly, you very rarely now see a targeted sanctions listing based on the conduct of the person on the list, because that is just too hard to sustain as a matter of evidence. So now, as a result of this case law, I think, you see far more of these sort of status-based sanctions. So someone is associated with a member of the government, or they're involved in a particular sector. That is clearly a lot easier to sustain than somebody, supports President Putin's war or something of that kind. The third thing they did is to start to rely on legal presumptions. So, for example, in the Syria case, particularly, if you are successful in business in Syria, you are presumed, unless you can prove otherwise, that you are connected with the Assad regime. That, to some extent, is applying now in the Belarus context as well. So the reliance on presumptions are much easier from a legal perspective because the burden of proof has shifted. And the fourth thing they did in response is the practice of relisting anyone, not anyone, but most people who had succeeded in annulling a targeted sanctions listing were simply relisted the next day by the European Council so that they never really ever came off sanctions lists. So since that time, the big focus of all of the cases in Luxembourg now has shifted away from process, because the process has been pretty well established for 15 or so years. Now it's all about the facts. So the only real cases that now the Luxembourg court engages in is whether there's been an error in the facts that are alleged about an individual. Very occasionally there's a process case or a case about the other fundamental principles of EU law, but generally speaking, that's where they will intervene. They will also interpret each of these listing criteria. So what do we mean by people associated with the regime? What does support for the government mean? They will sometimes, give interesting interpretations, but again, they are leaving completely alone the proportionality or appropriateness of anyone being on a list. No one has ever won a case on proportionality ever in the history of this case law, other than Mr. Cardi, in a context where there was no process, no reasons at all. And so the court had to say this is a disproportionate interference with his fundamental rights. So moving forwards to Russia, how does the current sort of Russia sanctions debate fit into all of this? Well, because of the need or perceived need by the EU to be strong when it comes to sanctions on Russia, we're sort of back to a big mixture of targeted sanctions and non-targeted sanctions. So there's a huge amount of both. The targeted sanctions are very attractive because it's pretty easy to get large numbers of names on lists. And that gives rise to some of the problems that we are addressing today. And the criteria for adding people to those lists, and I think the previous talk is very interesting on this, are very wide. And that's because of the history that I've just talked about. So now, because of the history of targeted sanctions, it's very easy for the EU legislature to have enacted sanctions which are pretty broad. So it's, to get on one of these targeted sanctions lists, although they are thought of as kleptocrat lists, Putin cronies, oligarchs, whatever the rhetoric that is used. In fact, when you look at the criteria for inclusion, they are things like being involved in sectors of importance to the Russian economy. Now, that's not the same as being a kleptocrat. whatever your definition of oligarch. So the criteria are wide, and they are these sort of status-based sanctions rather than alleging any particular kind of misconduct. That's probably not what, you know, the average person would think were these targeted sanctions. They might think that they're more aimed at those guilty of gross, you know, crimes, corruption, and so on. But anyway, the criteria are wide because of the history. And so what will the European Court do, and are they already doing when they're faced with these cases? They're looking at the facts to see if they can justify these rather broad criteria. And to some extent, they will interpret the criteria. But I think they won't really, you know, good or bad, I don't think they're really going to be interested in these arguments about, is it going to do any good to have this person on the list? I might be wrong, but that's my guess in view of the history of the case law. So, where are we in terms of the rule of law now? And then I'll just say a few words about what the UK has done. So I think that it is true that the administrative process in the EU, by which I mean the Council of Ministers and the interaction with the Council, is a pretty meaningless process. And I think that the open letter that's been written illustrates this well. And that the basic problem is there isn't really an agency, there isn't and never has been an administrative agency in the EU with resourcing and capabilities who are capable of gathering evidence for people on sanctions lists and answering questions and responding to representations by those on the list or by those not on lists but who are affected by sanctions. So what do all these provisions mean and so on. And so there is, I think, sometimes a problem with the sources of evidence that are relied on, although it's an awful lot better than it was. And sometimes, you know, the sources are at least decent publications. But there is definitely no engagement really with any representations that are made. And what does that mean? That means there is a huge reliance on the court to be the institution that safeguards the rule of law in this area. And this is the area where I think there is a problem, because the court, which was very, you know, the great bastion of the rule of law in this area, I think now is problematic when it comes to the case law. What do I mean? First of all, as a matter of process, it's extremely expensive to litigate in Luxembourg, and it takes an unbelievably long time. So these are individuals who are immediately affected by sanctions, or companies. There's no meaningful process of expedition. I don't think I've ever known expedition to be granted in a sanctions case, even in a Syria case where someone's receiving death threats from being on a sanctions list. Trying to understand the time limits for even bringing a case in Luxembourg, I think is, you know, even EU lawyers struggle sometimes with it. Because of the strict time limits in Luxembourg, even if there were a real administrative process, there's no time to engage in it because you have effectively 2 months and a bit more to get to court. So you're never going to hear back in time. So everyone ends up in the European Court. Apart from the process problems, you then have a real problem of the Pyrrhic victory, because what the court does in every single case now, I think it's every single case, is when somebody wins an annulment action, they suspend the effect of the judgment for 2 months to allow the council to relist someone if they're going to. And that means that even in a case where there's no evidence that this is someone who should be on the list, no evidence of dissipation of assets or anything of that kind, in every case the council will relist. And the court has upheld that practice as being compliant with the rule of law. So relistings, fine in a case where, of course, where there's new evidence or something new has happened. But there is one good, I think, order of the president of the General Court in one of the NITC cases where he says that what would be compliant with the rule of law is for the council to be required to make its case first time. And if all it's doing in a relisting case is changing the label for the same facts, or coming up with facts that it could have come up with in the first place, that's not compliant with the rule of law. He wasn't followed. When I've tried to make this argument, I've lost. So It is compliant with the rule of law in Luxembourg that you have this Kafkaesque process where someone is relisted forever without any new facts. The next aspect is no one ever recovers their costs in the European Court, so you will get a very small proportion. So even in a case where you win, it's an expensive process. Damages, almost impossible to get because the thresholds are so high. So yes, occasionally there is an award of damages, but the causation criteria and the requirement for there to be a sufficiently serious breach are interpreted so strictly that it's really very difficult. There is also a problem, I think, of evidence, not the problem identified in the letter, but this is not a court that will accept the sworn evidence of a CEO of a company, for example, as being credible evidence, because the European Court's view is that that is partisan. You would say that, wouldn't you? And also a tendency by the institutions not to believe people from certain countries, which I find pretty extraordinary. But you'll see if you try and put in a statement from someone based in Syria or North Korea, there will be a kind of, well, they would say that because they come from that part of the world type attitude. There's also extraordinarily no threshold of review in the European Court. So the Council has to have what is called a sufficiently solid factual basis for a listing. But that's not a standard. A sufficiently solid factual basis for what? For a reasonable belief by the Council? For a reasonable suspicion by the Council? There's simply no standard of review. So there's a real intangible element to what it is the Council has to show. And then, as I've said before, there's no case in which the Council really gets into what I expect most people in this room and their clients are concerned with, which is, will me being on this list actually do any good? The proportionality, really, of the measure and the limits of the common foreign and security policy is not really something policed by the court. Does any of this matter? Well, it matters if you care about the rule of law, but I also think it matters because the people on the lists now are so broadly drawn up that this isn't just, a list of the real baddies. This is a list of people in most cases going about their lawful business, which they've done for years. And for my money, the real problem, and I don't know whether Michael might talk a bit about this, is the lack of analysis about whether these sanctions are effective and how it is that they are supposed to work. So if you look at the sanctions regimes, what they say is not, here's what we're trying to do and here's how. They say, in view of the situation in Russia, we have these sanctions regimes, in view of the undermining of the rule of law. But that doesn't tell you how imposing asset freezes and travel bans on these people. So I'm not saying there shouldn't be targeted sanctions, far from it. I'm not saying a lot of these people shouldn't somehow be on lists, and it wouldn't be my job to say that. But I think it's a problem increasingly that there is no engagement with, if you do X, you might be able to come off this list, because the goal of these sanctions might actually have been achieved. And that is something the US, for all its problems, has done, I think, on a number of occasions, much more meaningfully. There are many other problems with the sanctions regimes, which really matter, I think, more than things like the lack of administrative process. The licensing systems, I think, are, the agencies are simply flooded, particularly in the UK. That's not really a system that's working hugely effectively. And these are provisions rushed out very quickly under huge pressure, with no one there really able to explain and answer questions. So a few words on the UK. What has the UK done? Well, it has, I think, a pretty interesting and good new system for sanctions. Very briefly, some of the things going on in the UK are not working so well. Mainly the government is absolutely flooded with questions and licensing applications, and it doesn't have the resources to deal with them. That means massive delays and great frustration. Secondly, there is very little enforcement of sanctions in the UK, and that's something Michael's going to talk a bit about. And there is exactly the same basic problem of no real engagement with how these are meant to work, what they're meant to do, and whether there's anything that can be done to change behavior and be delisted. However, this is my final point, The positives in the UK are quite positive in rule of law terms, I think, so far. And obviously we're in early days. First of all, the quality of the decision making is much higher coming out of the UK targeted sanctions listings than the EU. What do I mean by that? Well, if you ask on behalf of a client for why this person is on the list, in the UK you get something called the SDF, the Sanctions Decision Making, is it? Form, Sanctions Designation Form, which is a very, I mean, they vary in quality, but by and large there is a detailed reasoning given as to why this person has been selected, with reference to often a large number of exhibits, including a detailed analysis of proportionality. So what assets, that, as far as they know, they have in the UK, what effect this might have on them, why it's proportionate for them to be on the list. Secondly, there is, before you go to court in the UK, you have to go through a government review process. You have to request a delisting from the government, and there is then meaningful engagement. So you put in your reasons why you think someone should come off the list, the government responds, and there is no time limit for going to court in these cases. So there is actually a meaningful engagement and back and forth. And there is a pre-court process where you set out your legal reasons, the government have a chance to respond before you get to decide whether you're going to spend money going to court or not. Once you get to court, there's only been one decided case so far, but there are a few others coming through. You can get to court much more quickly. There is a recognizable threshold for evidence, even though it's a low one. There must be reasonable grounds to suspect that someone is on the list. And the court, I think, will, in these cases, get stuck in on whether there are sufficient facts to justify someone being on the list. They will also engage, this is me speculating, with the extent of the proportionality analysis. And we'll have to see, the government have insulated themselves from damages claims. So the legislation provides that they will only give damages in cases of bad faith. So anyway, as I say, we've only had one judgment. It's very early days, but it will be interesting to watch. And I've way exceeded my time, but I'll now hand over to Michael.
Afternoon, everybody. I'm going to be quick. I've got just a few points that I want to make. First of all, I want to say thank you very much for putting this together. I am bored going to sanctions conferences where the title of the sanctions conference is Navigating an Increasingly Complex Landscape of Sanctions. And then you have 25 compliance officers spending all day saying the same thing and you learn nothing. This subject is long overdue, and it should be something that should be being debated much more than simply kind of compliance with sanctions. I'm a humble criminal lawyer. My entry into sanctions was in 2011, when the misappropriation sanctions regimes against Tunisia, Libya, Egypt, Syria, then actually Ukraine in 2014 came into play. And I think that, the number of lawyers doing sanctions work has now, hugely increased over the last few years, and there's a connection between that and the amount of complaints that are being raised in relation to rule of law issues. But my basic point for you today is this: for all of you who legitimately, as lawyers, are complaining about the rule of law deficiencies when it comes to the field of sanctions, my position is you're wasting your time. You're wasting your time. When the rule of law comes up against the buzzsaw of political imperative will always triumph. And sanctions is the perfect example of this. If you don't sort of believe what it is that I'm saying, then let me just read you a recent quote from the National Security Advisor on the National Security Council's Deputy National Security Advisor in the United States from last month. In relation to Russian sanctions, he said the following, and he probably shouldn't have said this. Look, he said, in 2014, we didn't win the narrative with Russia. So this time, let's seize the physical assets of the kleptocracy, the yachts, the fancy cars, the luxury apartments, not so much because we thought the owners of these assets could influence Putin, but it was intended to be a demonstration to the Russian people that they've been getting ripped off for years. So he was essentially articulating what is the real reason why sanctions have been imposed against the so-called oligarchs. It's propaganda. It's political propaganda. Now, my other point that I want to make to you is that the answer to this question has to be viewed in context with the other sanctioning regimes, because obviously the EU sanctioning regime is hugely important. The most important sanctioning regime is the United States. And obviously, it acts with its allies, the United Kingdom, Canada, Australia, New Zealand, and Japan. But as a consequence of what's been done to Russia, it's the first time swingeing sanctions have been imposed on a UN Security Council member, a country with 140 million people, a country that has the power to insulate itself from sanctions measures. Russia is now doing this. We can see this. There are plenty of examples of it. But the most important thing to say about this is that China has learned all the lessons, and China is also now doing exactly the same. So we are beyond the high watermark of the effectiveness of Western sanctions. They are never going to be as effective as they have been in the recent past. And I'll talk about why I say that in just a moment. So Maya took you through a brief history of sanctions from a rule of law perspective, how they came to be imposed. I just want to say to you, of course, there have been sanctions for many, many years. And in fact, there was an example given by Anne this morning about sanctions being imposed by Napoleon on the British in 1806. Very pertinently, Anna, 6 years later, Napoleon withdrew those sanctions because it was hurting the French economy much more than it was hurting the British economy. So that's a very important lesson for all of us to try to remember, because I suspect the same thing may happen here. Now, sanctions have really ratcheted up since 2004 because we had the disastrous Afghanistan and Iraq wars, and the Americans don't want to put troops on the ground, and they want something that they can say is a sensible political message. So they've increased sanctions. The European Union has followed suit. The United Kingdom does what the Americans also do. So now we have a situation where one global superpower, the United States, is imposing sanctions on two global powers, China and Russia, and has forced Russia into the arms of China. Xi Jinping spent 3 days in Moscow this week. So as a consequence of that, and that alliance between Russia and China, what we're going to see is an increasing, we see this now with trade and with harmonization, when it comes to banking, whether it comes to semiconductors, you're going to see that the United States' influence and the EU's influence to try to change the behavior of countries who behave in a way that they don't like is going to become more and more difficult. So now I said to you I come at it from a criminal lawyer's perspective. So let me just give you a flavor of what I mean. The United States drives the train on global sanctions enforcement. The United States drives the train on global white-collar crime enforcement. The United States drives the train on global cartel enforcement. And they do that by having extraterritorial jurisdiction, which allows them to go after companies that engage in trade with the US dollar, or where there is any potential jurisdictional hook by the United States. So it's very important to remember that when you're thinking about why it is that EU member states are acting in the way that they are in relation to sanctions enforcement. The other thing to say about the way that the United States operates is that the prosecutorial departments, whether it's the Southern District of New York, the Eastern District of New York, the white-collar crime division within the US Department of Justice, they act in a much more blatantly political way than prosecuting agencies in most other parts of the world. There is no doubt about that. Since 2009, OFAC has issued $4 billion worth of fines. 300 million of that 4 billion were against US companies. Or you might say, well, that's because, Michael, US companies are so compliant with sanctions law, so the foreigners are the ones that have to be beaten around the head. If you look into the data of this, you will find that if you are a US company conducting the same sanctions breach, you will face a fine which is 70 times less than a foreign country. So as a consequence, so the United States, OFAC and the US Department of Justice are sort of acting as an arm of the US Trade Department. Now, I just wanted to, again, if you're skeptical about what it is that I'm saying, I want to just read you a short quote, because I've spent my life, and many people in this room spend their life, dealing with mutual legal assistance, extradition, Interpol. In the European arrest warrant, one of the very few grounds upon which a court can refuse the European arrest warrant is if the crime is politically motivated. That's true in relation to Interpol. You can have red notices removed. You can stop mutual legal assistance. Politically motivated crime. When Oleg Deripaska's indictment was opened on the 29th of September by the US Department of Justice in the Southern District of New York for, amongst other things, paying for his girlfriend to go to the United States to have a baby, the prosecutor, so not a politician, the prosecutor for the Southern District of New York said the following: "This indictment, unsealed today, signals the United States' ongoing support for the people of Ukraine in the face of continued Russian belligerence." That's a prosecutor. Now, that's a political statement. In my opinion, that's a political statement. It is when prosecutors start bringing cases for blatantly political reasons, where is the rule of law? And how can it be said that we're not playing into the hands of people like Putin, and we are perverting our own systems in order to achieve some short-term political gain? The sanctions that have been imposed in relation to Russia, we may have won a short-term tactical battle, but we have lost a long-term strategic one. And the other thing that I just want to mention very briefly, because I know I'm going sort of way over time, is insofar as whether they've gone too far is concerned, we've talked about the oligarchs. There's lots and lots and lots of people who've been sanctioned have absolutely nothing to do with influencing President Putin. Sanctions were originally threatened. Some of you may remember Boris Johnson's statement that if the toe cap of a Russian boot crosses the Ukrainian border, there's a vast raft of internationally agreed sanctions ready to go. That was not true. That was not true, because when Russia invaded Ukraine on the 24th of February, the sanctions that were imposed by the British were against 3 small Crimean banks and 2 individuals who'd been sanctioned in the United States in 2018. And the reason for that was because the Americans were ready to go, but the Europeans were not ready to go. And the British were not ready to go because they are so much more dependent on the Russian economy and Russian oil and gas than the Americans are. So it's got to be thought about then what was the point of that? The point of it was to prevent Ukraine being invaded. So that failed. So that sanctions objective totally failed. Now, what is the sanctions objective? The sanctions objective, as set out by the British Foreign Office, is to signal to President Putin and to the Russian government that its actions in Ukraine are unacceptable. It is to force them back to the table in relation to the Minsk Accords. And it is to disable Putin's ability to fund what they describe as the illegal war. Now, is that really what is happening? We now have 15 million tons of oil pre-war being exported by Russia. It's now 14 million. We have a situation where money that would have left Russia and gone to Western businesses, companies where the holding companies are in Jersey, Guernsey, London, listed on the stock exchange, paid out in dividends, that money now stays in Russia to be taxed by the Russian government, with the money then being used to fund the illegal war in Ukraine. There are examples of where these sanctions brought in without proper thought for political purposes have not been thought through and could actually be undermining the objective for which they were originally intended. And we've seen this. We have an example of this, a clear example of this, which is public. When the OFAC froze EN Plus, Deripaska's holding company, back in 2018, he was forced to sell his Rusal shares. Who did he sell his Rusal shares to? He sold them to VTB Bank. So the money went to the Kremlin. Maybe some of that money has been used to fund the war. So you have to be careful what you wish for. I'm going to stop now in just a moment. Say one final thing. So what's the future going to be? I've said rule of law, buzzsaw, political imperative, boom. So the political imperative has to change. The only way I see it changing, because I'm a firm believer that the US runs the world, the only way I see it changing is with the US election in November of next year. If there is a Republican elected, whoever that is, then I think we're going to see a wholesale change in the way in which foreign policy with the United States is being done overseas, and that will have an impact and the dilution on the way in which the European Union does it. If the Democrats win, if Joe Biden wins, we'll just have more of the same. So I'm sorry, that was a bit of a political speech, but I thought we'd have something to talk about over lunch.
Thank you very much, Maya and Michael, for your insights. I'm sure there are plenty of comments and questions from the audience.
Regarding what we can hope for, I'm trying to connect what Maya Lester told us and what you just said. If before Caddy there was no Caddy, after Caddy there was a change. I do agree that we won't change everything, but I think what we're fighting for and this open letter that we got out, first of all, is just the first step. We'll try to do more. And on that, maybe Maya Lester, you can give us your input on what we can hope for, if we can hope for something. I think what we're trying to achieve is only changes in terms of due process. Some things can be changed. They're not enormous things. We're not going to change the world. But what you mentioned about what evidence can be used in terms of date. Can you use something which was already there when you first listed and then you're patching up 6 months after that? Can something, I mean, for God's sake, be done regarding getting out of the listing system once you've got an annulment decision? I mean, these are things I imagine that can change as things were changed after Caddy. And I mean, sometimes there are successes because some, say, just obvious procedural rules and requirements in terms of rule of law, I mean, make their way through. And all the examples you gave, that the first instance rejected, and then the court said, no, the threshold applies. So, I mean, if there had been no attempts, we would still be with what was at one time in extradition in France anyway, what I know about, which was extradition. There was no judicial review. It was just act of government and that's it, which could be what is about sanctions, but then, you know, okay, there's nothing to say. But it seems to me that, I mean, we can do something. I'd like your views on that.
So just on the what you could hope to achieve, I am not optimistic that the letter will have any effect. I might be wrong. Why? Because the only time really the councils, I mean, the letter is aimed at the council, quite specific complaints about the administrative process. My focus is not so, I mean, I think I agree, but I think there are other problems. But the only time the council has ever fundamentally changed the system is when the court said it had to. And when the court, and that was because there was a great fear that, you know, the court would start annulling all of the designations. But in terms of the particular complaints, the quality of evidence not being great, to a certain extent, I think it will be said that's unavoidable. What would you suggest if you're going to have EU autonomous measures? You're not going to have people going out to Russia and taking sworn witness statements, or people standing trial. You know, they are dependent on open source searches. You could have more effective intelligence sharing, maybe, but I don't see any real impetus for that part to change. Yes, they should be corresponding much more effectively with parties, but I don't think the court's probably going to tell them they have to do that, because effectively everyone ends up in judicial review, and the court will itself say they have safeguards because they have case law saying that the council, the court will consider what weight to place on the different evidence depending on how probative it is and so on. So I think that, and also because, as I've described, at every single stage in the process, understandably, the institutions were very resistant to any change and tried in every instance to make it unique to the particular situation of that one case that ended up in court. So I think unless you can find a an inroad with the council to explain why they really have to make this change or why it's in their interest to do so, I suspect it's unlikely that very much on the administrative side will change. I don't know. Let's discuss.
I agree with that. All I would say, just in addition to that, is just a couple of things. First of all, we saw the reaction of the EU institutions to the court's decision in relation to Prozogin's mother. So now they're saying, well, we've got to change the law. Got to change the law. So you might make, you can sort of scream and kick and win in court, but then they change the law. And they've done that in the UK in relation to wives, husbands, and children and grandchildren. The other thing I would say, we haven't had a chance to really talk about it, but it's a big subject, is this political imperative that I'm talking about, riding roughshod over the rule of law, is now starting to show itself in relation to not freezing, but seizing. So there's all this talk about confiscating. We've now the law now been passed in Canada and enacted, and they're taking measures in Canada with very, very little judicial oversight on the basis where you don't get provided with the evidence from the Canadian authorities in advance. It's a pure opinion by somebody within the Canadian Foreign Directorate. There's been two attempts in the British Parliament now to try to enact something similar. First one failed. The second one is going to be to confiscate assets that are not disclosed. And that one may have a bit more success. And obviously the European Union is trying to find a way, essentially it's trying to find a way, they're all scratching their heads thinking, how do we get around Article 1, Protocol 1 of the European Convention for Human Rights, the right to enjoy your own property? That's the problem. And I'm sure many of them would like to, can we just sort of scrap that for Russians if we can? And they're being told by eminent public lawyers that that's impossible.
Additional questions there? But maybe just.
First point, which I wanted to add to Michael's rather pessimistic, if I understood you well, understanding about the realistic, but maybe pessimistic understanding of the impact which the rule of law topic might have on the entire process. I think that there is let me be more differentiated. I see no whatsoever hope in the near future that the political decision-making process is going to start to be more adequate. They will not, just the opposite. You can see that even today, after the 10th package, they claim for the 11th package and so on. And so the radicalization of the political intentions coming from the Baltikum and Poland is here. So the political process, no, they will not change it. They are completely driven by the worries that a single person to be delisted will break the system. So I think this is rather clear. I am a little bit more optimistic in the judicial development. And if I see it from where all of us started last year, April, till today, I think we need to be, we need to apply historic perspective in a very short historic frame. Because the way from Russia today to Mazepin or Prigozhin is huge. It's huge. I never read something like Russia today. Never, ever. And having been working so many cases at the ECHR about Article 10 of the convention, and then reading a bullshit like Russia today, I never had this in hand, something like that. And from there, in a symbolic name like Prigozhin, to have a decision like this one in Mazepin, this is tremendous. So, in the frame of history, I think, and my hope is, and I'm sorry to be a little bit political because you opened the bridge for that, and I try to go into that because it's necessary. I believe deeply that the colleague judges sitting there, and our friend Victor is having been judged till recently, so he knows the psychology maybe much better than me. But I think that there is a certain point of no return for some of the judges, mainly Spielmann. Yeah, they don't want to be these guys, I feel. Yeah, and there is a limit. There's a borderline which has been overpassed, and they try to go for that. And this is the only reason why this incredible Russia Today decision, I think, and some of the reactions of the council, because the issue, exactly what you explained, what you described, that is completely useless. You have this perpetuum mobile of illegal sanctions in the way it is done. I hope that this is the little centimeter too much. So, yeah, but let's discuss it. I do believe that in this, and then the next question is, when does this development of jurisprudence, of jurisdiction, when does it has the effect on the system? Yeah, and here I'm rather skeptical. See point below. Yeah, but if they feel that, as Maya was saying, due to the foreseeable situation in the court, the colleagues, the legal departments in the council might understand that their case is so weak that the system breaks. Maybe this might be the situation when it changes a little bit, but we do know that in special cases, statements of the legal department have been completely ignored by the political elite. Yeah? So I don't know how this is. Last point, pre-last point. Yes, I do feel that the United States system is so much more functional. It's better. It's better out of many reasons. They are more able to have smart sanctions. I'm coming from big cases from fertilizer, and you might know in general licenses, comfort letters, intelligent products of the United States law of sanctions, complete lack of this kind of intelligence in our European Union law system, with dramatic consequences on people, on business, on everything. Yeah? So I think we have to be outspoken in the dimension in which the unprofessionality of the union structures are behaving. Yeah? And now I'm coming to the last point. I very much appreciate, William, your position and the position of our colleague over there, with being outspoken with our letters and with other stuff which we need to do in this respect. I think that this is, I do not understand why bar associations, including a European one, are sleeping, and we need to try to wake them up. And because I do agree that this has never, ever occurred. I mean, the way in which lawyers are proud that Russians can have no lawyers anymore. I remember that we had a call in the Financial Crime Academy. You know that. I think 9 months ago, general consensus was, we are so proud that it's no Russian anymore, any lawyer in UK. You know, but very interesting. Half a year later, all the law firms appeared and were trying to get to be part of the cake, and all those fantastic moral reservations, by miracle of fees maybe, or of, I don't know, or changed conviction, whatever, changed. Yeah. So, you know, the stuff with the morality is also a little bit prostitutive, and morality is not only prostitutive but also relative. So yeah.
Should we take one more immediately? Yeah.
Hi, good afternoon, everybody. My name is Peter McNamee. I'm here on behalf of the Council of Bars and Law Societies. I just want to provide some clarification that we haven't actually been sleeping. Like, the sanctions package came out on the 6th of October. We met on the 7th of October. We've met a number of times since. We have a CCP pool of experts on sanctions. We're considering intervention on Friday of next week. We've also contacted all our bars and law societies 3 to 4 times on the practical and legal implications of the sanctions. So it's something that we're very much on top of and following. It's just a small clarification. Thanks for the opportunity.
Any reactions from to the 2 interventions? No? Yes, just please.
I would share the limited optimism, but not with regard to the fact that legal considerations will prevail over political considerations, but due to the fact that political considerations should change. And if only it's becoming more and more clear that sanctions, in a way they've been imposed and kept, are not giving any positive effect, then perhaps politicians should change their view and should exploit more sophisticated approach towards sanctions.
I have one question to both of you. I guess you sort of seem to imply through your respective speeches that this sort of the US kind of system of sanctioning is more efficient and is more smart. You know, the way they sort of approach the sanctioning process is more targeted and sort of and there is this sort of disaccord of 27 national member states in the EU that sort of creates a lot of inefficiencies. And in that respect, I just wanted to ask if you think the initiative to create the sort of the European equivalent of OFAC would sort of change things. But the perspective I wanted to ask you is if the American system is more efficient, you would probably agree that very few were able to actually challenge their individual designations in the US. So if with the creation of the European equivalent of OFAC, the European system will become as efficient as the US one, does it mean that there will be the same thing in the EU? Because at least until now, there is existing court practice in the EU courts of cases being successfully challenged, at least on those sort of limited grounds. But at least there is some practice, whereas in the US, there is none. So what's the benefit?
I was going to comment on this actually from the previous intervention, but just on the US, I mean, I definitely was not advocating for the US system. I do think they're obviously just infinitely better resourced. So they enforce sanctions in a way that no member state is enforcing sanctions in terms of breach. But they also, at least to some extent, answer questions and are available for some element of discussion about the meaning of sanctions and so on. But I completely agree. In rule of law terms, I think any US lawyer would say that the US system is not, if what you care about is fairness to those targeted by sanctions, then that's not a high priority for the US. And you can, hasn't changed that much since the system post 9/11 that I was talking about. So you get, the classified record is basically what's relied on in the US, and that's shared with the court, but not the designated person. The standard of judicial review is so arbitrary and capricious, is virtually impossible to overcome. There are some challenges in the US, but also constitutional. So the European Court has said that anyone, you could say it's remarkable that anyone on an EU sanctions list who is not an EU national can go to the European Court and challenge the designation. There's no issue about that. In the US, constitutional rights are not granted to most people on sanctions lists because they're not US citizens and they don't have property in the US, and the case law on that is pretty limited. So I would agree with that, but for the more political US perspective,
Yes, I certainly wasn't advocating that the US system is better than any other system. In fact, I was saying it's blatantly political and it's gone far too far. I totally agree with you that it's very difficult to get off the list. However, with one important caveat, and I do think this is something that the European Union and certainly the United Kingdom could learn a lesson from with the United States. Insofar as the US sanctions are concerned in relation to Russia, the main body dealing with it is the Klepto Capture Task Force. You can actually pick up the phone or send an email. You can go and have a meeting with them. You can sit down with them on behalf of a client, or hypothetically, on behalf of a client, and say, okay, what do I need to do to get off the list? You can have that conversation. You cannot have that conversation with anybody in Brussels, and you certainly cannot have that conversation with anybody in the Foreign Office in London. So I certainly think that's worth looking at and trying to change. But the reason for that is they have a slightly different system. OFAC's been doing it for 70 years. They're very self-confident. They, they're very, very used. All these lawyers on the Klepto Capture Task Force, they're all criminal prosecutors. And all they do all day long is reach plea deals with individuals who they've indicted. So they are very, very used to having these sort of negotiations. And I think in Brussels and in London, it's not in their DNA. Certainly not yet.
Thank you. I think we can take one more question and then a comment.
Sorry, Carsten Zatchler again of the Bar of Ireland. More comment than a question to inject hopefully a bit of pre-lunch optimism here as regards rule of law challenges. I think couldn't agree more that in sanctions cases it's difficult at the moment. And sanctions is not the best area to try and develop rule of law at the moment. I'm rather hoping, nevertheless, that Court of Justice sees the case law developing across the board as regards rule of law, and that the sanctions case law might well be infected, so to speak, by rule of law principles from other areas of the case law, where there is a bit of litigation going on. We've seen the cases against Poland, Hungary, the infringement proceedings. There are a lot of rule of law proceedings pending now, the infringement proceedings just brought by the European Commission regarding the Polish Constitutional Tribunal ignoring EU rule of law standards. I have a series of cases myself in Luxembourg at the moment challenging Council and Commission as regards rule of law standards being applied in the recovery and resilience facility funding for Poland currently. That has got into the expedited procedure now. So we're hoping that that's going to be dealt with quickly. There are standing problems very often when you bring sort of broad rule of law challenges, but I am rather hoping that actually I'm just reading speech by Koen Lennarts in Sofia at the beginning of the month, the rule of law and the constitutional identity of the European Union, where he, at least, I haven't gotten all the way to the end yet, but at the beginning it looks promising about rule of law, being very much the foundation of the case law, still, fortunately for all of us. So what I'm rather hoping is that rule of law will be so entrenched in the Polish and Hungarian cases that it's going to be impossible to ignore once they are properly pleaded in a sanctions case. Anyway, that's my thought. I don't know whether you've got any thoughts or responses, or whether lunch calls.
Well, then, thank you very much for this final comment. You mentioned the word lunch, and I see nobody else who wants to stand between us and lunch. So before we break for lunch, I think, which will be for 60 minutes, and we'll, if that's okay with the organizer, and that means we'll resume at 2:30. I'd invite you to join me for a final round of applause for our speakers for this terrific morning session. Thank you. Thank you all.
Uwe Wolf from NAИMA for having me here to moderate and facilitate this very substantial session, and for the valuable audience we have both in the room and online, and we greet our observers online, and we do apologize for being a little bit late on the program, but this is due to the numerous questions that the debate have generated. As a specialist of emerging markets, I would like first to, well, no, before talking about emerging markets, I would like just you all to have a thought on the people in Ukraine and in Russia who are having a hard time, because we're here sitting, you know, as white-collar bureaucrats and nerds and professionals, where, you know, we can have a thought about the people who are on the ground over there. Secondly, here, you know, I would like to drop a message of hope, because being a Belgian, Belgium has been the territory of many wars for 2,000 years. You know, everybody who wanted to punch on the other's face has been doing this in Belgium. And the good thing is that we have always managed to have, after a war, a period of peace and a period of wealth. And indeed, one of the reasons why we have this long period of peace is because of the European Union. And the European Union actually was born slightly after one of the most awful war, and just a few years after. And what makes the let's say, peace is actually that we managed to find an economic patrimonium that we can share. And so I know there are many lawyers and many regulators here in the room, but economics are going to play a key role for the aftermath. So just a humble and modest token of witness concerning emerging markets, because I'm an economist, I'm not a lawyer. Emerging markets are really important, and it's a notion that is very moving. Just like oligarch is an interesting concept, emerging markets are also an interesting concept. And if you would remember the acronym of the BRICS, do you remember the BRICS? Well, the R of the BRICS stands for Russia. So not so long ago, actually, Russia was an emerging market. And talking about emerging markets, there are many different ways to define them. But one of them is the geopolitical happening. And let's take three recent examples. One is Iran. Well, Iran has been an emerging market where many Europeans, many sovereign delegations, ministers, prime minister have been visiting Iran until Mr. Trump decided to launch some sanction on Iran, and then it was finished. Iran was no more an emerging market. Let's have a look at Saudi Arabia. Not so long ago, you know, the murder of the journalists in Turkey, in the Saudi embassy in Turkey, has created quite a lot of appraisal. And, you know, Saudi Arabia was sanctioned and boycotted, but suddenly now all the sovereign delegations, prime ministers, presidents are queuing to come and meet Mr. Ben Salman. Let's look at the Abraham Accords between Israel and the Emirates and other countries such as Sudan, Morocco, Bahrain, and so on. It's quite interesting that here, you know, when you talk to people on the ground, they're telling me, you know, when I visit or Dubai office, they're telling me, you know, it's very strange because I have been taught all my life to hate the Israelis, and then suddenly overnight I should welcome them and love them and do business with them. That's a very strange thing. So what I'm trying to put here in perspective is that sanctions, just like emerging markets, are something that is very moving. You know, so just a humble thought, you know, linked to my understanding of the economics playing a role in the sanctions. Now is actually a time for you to hear two very skillful, competent experts on the legal side of sanctions. And that is namely Tamara Kayani, who's the founder of family offices based in Luxembourg, but active actually in many different jurisdictions. And Dominique Griset, who is the managing partner of Griset and Partners, that has its HQ here in Brussels, but that has offices in several jurisdictions, and who has been an important figure of defending some very sanctioned individuals and companies in recent years. So they will first tackle the second block of today's happening on legal advisory services and sanction. Then after, I will call a defense lawyer to the floor. That will be William Julier, and then we will have our coffee break. So now the floor is yours, Tamara and Dominique. Thank you.
Okay. No, tu peux même aller à la page 3. Okay, ladies and gentlemen, dear colleagues, I'm very happy to be given the opportunity to discuss with you this afternoon. But unlike what has been done this morning, my approach will be very practical. I will try to explain to you how we can try to defreeze some assets which have been frozen. So, no, please stay on the first. Yes. There are, in fact, two situations to be considered. The first one is the situation in which assets have been frozen because a person or a company, already calling me? David. So the first situation is assets have been frozen because a person or a company has been listed in those famous annexes. So there, the idea is you try to unlist or to delist the person, and logically speaking, if you succeed, you should be able to recover the assets. We have discussed this morning the fact that once you get somebody out of the list, he is almost immediately put again on the same lists. But that's not what I'm going to discuss. The second situation is a more tricky one. It is the situation in which a company or a natural person has some of its mostly bonds frozen, not because he's on the list, but because he has given these bonds in custody to somebody else who is listed or who has given, I will come back, the bonds to a Russian bank or the NSD. I will explain the situation. So let's move to the first situation, which has already been discussed this morning. Yes. Okay, we have been discussing quite at long how a person ends up on the sanctions list, the fact that it is or not documented is, of course, at the heart of the question, and we have spent some time already, so I'm not going to get into that again. However, I thought that it was timely to come back to this very nice example, which is the example of Violetta Prigozina, the mother of the boss of Wagner. So, why was she put on the sanctions list? This is the extract of the decision which puts her on the sanctions list. So Violetta Prigozina, associated individuals, and then of course you have the son, you have the daughter-in-law, she's Russian, she's female, she's the mother of Evgeny Prigozhin, an owner of Concord Management and Consulting LLC, which belongs to the Concord Group, founded and owned until 2019 by her son. So That's it. She is the owner of other companies, not listed here, with links to his son. She is associated with Yevgeny Prigozhin, who is responsible for the deployment of Wagner Group mercenaries in Ukraine and for benefiting from large public contracts with the Russian Ministry of Defense following the illegal annexation of Crimea by Russia and occupation of eastern Ukraine by Russia-backed separatists. She has therefore, this is delicious, of course, she has therefore supported actions and policies which undermine the territorial integrity, sovereignty, and independence of Ukraine. So this is what you actually find on the lists. Apparently, she did not agree with this classification, and so she started an annulment procedure. So I don't want again to repeat what has been said this morning. In this case, when you have been put on a list and you believe you do not meet the criteria to be on this list, you have the right to request the annulment of the decision because it is something which hurts you personally and individually. So here you are, you can try. If you're lucky, you will be taken out of the list. What you cannot do, and this has been said this morning, as an individual, don't try to overrule a complete legislation. You will not succeed. It is not possible. There's lots of very interesting decisions going back in time, and we were citing Koen Leenaerts, who has been very busy with all these things years ago with the convention and so on. But it's clear today, no way you're not going to be able to have a general annulment. So what happens to Violeta? Let's see that. What did the court decide? This is just not the development, but just the main part. The general courts, I think it's taken from the press release. The general courts annuls the restrictive measures applied to Ms. Violeta Prigozhina, mother of Yevgeny, in the context of Russia's war against Ukraine, even if the latter is responsible for actions undermining the territorial integrity, sovereignty, and independence of Ukraine. The link between Ms. Prigozhina and her son, established at the time of the adoption of the contested acts, is based solely on their family relationship and is therefore, here comes the therefore again, not sufficient to justify her inclusion on the contested lists. I do suppose that next time they will find the other companies they were referring to. But this is interesting because, of course, if a person who has been listed has seen its assets, properties, funds, bonds, whatever you can imagine, seized, normally, once the court takes a decision, of course, this is only a first step. You have an appeal procedure. But logically, goods should be defrozen. And as was mentioned this morning, it never happens. It never happens. And if it was to happen, and this is something I think is important, or this is something we should, as lawyers, pursue, if we get somebody out of the list, we should immediately start the national procedure to defreeze, which is something we do not do. And this is an important point for me. This should be immediately done as soon as the decision is taken. So this was the first case, and to some extent it was already discussed this morning. Now, we have the other situation, which is a little more tricky. So we are talking about assets. Which are the assets concerned? What can be frozen? I'm not going to give you any novelty, but we're talking funds, properties, stocks, shares, bonds, accounts, cash, everything you find, you just seize. Okay, that's something you will do. Now, as far as Belgium is concerned, but I think it's a very important field, we have been very concerned with the bonds. And why have we been concerned by the bonds? Because there is an awful lot of money in bonds in the Euroclear system here in Belgium. How does it happen? Well, we will see that there are 3 different situations which lead to the problem we are going to discuss. First of all, well, you may have a bank, a Russian bank, not listed. There are a lot of non-listed Russian banks, which is going to buy some bonds, what we saw, Netflix bonds or Alibaba bonds. We're not talking about anything else than that. And they're not listed. They have those bonds. It's perfectly lawful. It should not be seized. However, the system in Russia goes this way. The bank usually sends the bonds or has a deposit agreement with the Bank of Russia, which itself has a deposit agreement with what is called the NSD, and the NSD pushes the bonds to Belgium, and that's the way it arrives in Belgium. What did they check when they decided to seize? Well, they checked the last step. The NSD, as you can imagine, is listed. So let's seize everything. So example number 1, I'm a not listed bank, and all the bonds I have bought, they have been seized because of deposit agreements, which of course do not prove the fact that you own the bonds. So that's number 1. Now, a little more tricky. The client of a non-listed bank, a non-listed client of a non-listed bank buys some bonds and tells his bank, keep my bonds. What does the non-listed bank do? Same thing as earlier. Sends the bonds to the Bank of Russia, will be sending the bonds back to the NSD, and here we are, back again in Belgium. What do we do here? We seize, although the client, the owner, is not listed, and the bank is not listed. Now, the trickiest situation is the third one. I am a non-listed client or company, and my bank is a listed bank, and I buy bonds, always the Alibaba bonds or shares and the Netflix shares, and I buy them through my bank. And I deposit my bonds with this bank, who then blah, 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 blah. The bonds arrive here, and the bonds are seized. So there is a series of deposit agreements, but none of them changes the ownership. It is still somebody who is not listed who possesses the bonds. And this is the situation in which really huge amounts are today. So what can we do? What do the sanction regulations say about this kind of situation? To summarize very simply, nothing. Nothing. If you look at the sanction regulation, you will see Article 2, what can be seized. All funds and resources belonging to people listed shall be frozen. That's Article 2. And then, and this is very interesting for the rest of the development, then they will tell you in the regulation, in some instances, how you can defreeze some very specific amounts. You can ask to defreeze some amounts which are going to be used to rebuild Ukraine. We were discussing about this possibility of devoting part of the amounts you own to the reconstruction of Ukraine. Much more important for us here in this room, you can, as a lawyer, request payment of your fees, which can be distracted from the seized amounts. And you have a lot of very funny exceptions, if you look at them, which are always linked with very specific economic interest. Nothing concerning bonds which have been frozen by people not listed. Nothing. So in fact, you have no solution in the regulation. And the difficulty is that the procedure is the same. Europe is not competent to decide how you unfreeze. They said that it's at national level. So you should have a national procedure to help you defreeze these goods. But they haven't made any difference between the situations. So you have to use, in fact, the same system as you use to defreeze funds which have been lawfully seized. So, I'm a little, that's yours. Wait a second. So how do we proceed? How do we do things? Well, we have to work by analogy. We lawyers, we know that, we know this system. So in fact, if you want to defreeze the type of assets I was describing earlier, well, you will start a procedure. To take the Belgian example, and once again, it's because there is, I tell you, I mean, we're talking about 10 files, 12 files, enormous amounts, which are frozen here. Well, you have, in fact, in Belgium, to take contact with the Treasury. We were talking about administration a little earlier this morning. Well, the administration in Belgium is even worse than anywhere else in Europe. It's terrible. It's terrible. If you try, nowadays I have files there, if I try to call, you don't get answers. I usually stay, I had a contact, I'm very happy I had a contact. The same contact told me 3 weeks in a row that they were very happy because they got new people in the administration and that soon the files would be given to the new people and that hopefully that we would receive a first letter somewhere around. When, we don't know. So that's the situation. And then what must you show to the administration? Well, the most important thing, and I will leave the floor to Tamara to explain how we do it, how we decided we would do it. We do it from the scratch. Before opening the file, we check the compliance. Why do we check compliance? Because if we don't, and if we advise people who are somewhere listed directly, indirectly, through subsidiaries, then we are on the wrong side of the legislation. We are not allowed, as you know, to give advice. So before taking the client, before opening the file, we check the compliance, and this is a very complicated system. Then, as I will explain to you afterwards, we will have to sign a guarantor contract and a sales contract, and I will tell you a little more about that, but you need to listen carefully to the compliance part of the speech.
Yes, so for lawyers or institutionals that are familiar with compliance, you know that over the past years, banks have requested more and more. When you open a bank account, it's not as fast as in the past. And when you need to explain some flows, especially most of you are international lawyers, you know that your banker can sometimes ask tricky questions. Here, we are going at the utmost level. So before we even accept to onboard or to consider a prospect as a customer, we are going to dissecate, and I really use that word, from top to down. So 360 degrees, we are going to look through, find all the ultimate beneficial owners, find all the layering structures, who is director of those structure, and who is maybe legally not a director, but as a power on that structure. And then we go till our target customer, and then we will go all the layer down. With the look-through procedure, we will go through all the subsidiaries and to all the directors and all the people that have power on the management of those companies and through all the assets. So this is a real extensive work that, of course, you can use traditional systems. You can use WordCheck, you can use Dow Jones, and there are 10 systems on the market. You need a lot of IT infrastructure, software, filters, analysis, but most of it you cannot automate a compliance check. So you need people that are familiar with the news, that are familiar with what is going on every country, every jurisdiction, where this institution would have shareholders or would have participations. At this stage, we are using economic intelligence units to investigate in each of the countries or jurisdiction in order to make sure, to the fullest of our knowledge, that nobody is concerned by the sanction regulations. So that's the most important work, and the file we are going to present in the end will demonstrate all this to the supervisor or to the administrator of the Treasury that is going to review the file. So that's really the key point, and it takes really extensive stuff, extensive systems, extensive economic intelligence network to find out to the look-through detail. And this has to be presented in a way that a member of the administration is able to have a full overview and to make sure that you have done your fullest due diligence. So this is for the first part, that is just, I would say, a know your customer basis. Then we are going to have a second part that is to prove that each of the bond that you are going to ask the administration to defreeze has been really acquired by the person or the company you are defending. So there we go. We are still under compliance level, but we go more on audit and financial flows investigation in order to prove that from the moment the bond was acquired until today, it's really belonging to the person you are defending. So that is more audit methods, financial analysis methods, and that's also a lot of banking regulation and custodian compliance. So we are quite familiar with Euroclear procedures, and with other central custody in Europe that are having this issue. So not only compliance from a KYC point of view, but also compliance from a historical track and audit point of view. So I think this is summarized, and if we have more time, we can go through the particulars.
Just to tell you about an experience which might start and which is linked to the difficulty of the compliance. We have been approached, but have not accepted at the moment, by a listed bank who has 80,000 non-listed clients. So I could have a talk with the administration to try to find out a system to present the files for the customers of the bank. And it is possible because we have terrible machinery, computer machinery, so we can, in fact, slice up the compliance process. And while I was talking with people from the Treasury, we said that we agreed on something that might work, and that would allow, and this is quite important, the 80,000 clients who have small amounts blocked, which together, of course, form a big amount, but people who have just, their economies, they have their own bonds. That would be a way to realize the defreezing of these bonds. But the operation has not yet begun, but it is possible. But I can tell you, really very complicated. We are breaking our heads on the solutions. Now, why is compliance so important? Well, back at the sanctions regulation. It's because the system says, before listening to you, we need someone who will take the bullet if the answer is not correct. And that is called the guarantor, and the guarantor is usually a lawyer. But it's a very heavy responsibility. And you can only accept it, I think, if you have made a thorough compliance analysis as the one we are doing in our firm. So the next step is the guarantor contract. It's not a very complicated contract. It says that the lawyer who is transferring the request knows the danger, and he's satisfied with all the documentation he has received. He will send it to the administration, and voila. He knows the risks. You have to refer to the risk, and you have to sign, which is quite something to do at the moment you sign, because usually, let's speak about banks who have unduly frozen bonds. Well, we're usually talking about big amounts. So it's a big responsibility. Okay. Trying to not to lose too much time. So another strange point is that normally, if I have bonds which have been frozen unduly, well, if I can prove that they have been unduly frozen, just give me my bonds back. I want my bonds. I don't want to sell my Alibabas. I don't want to sell my Netflix bonds. Give them to me. No. Because the exceptions in the regulation, they foresee very limited possibilities to sell defrozen bonds. Only when you have to pay the lawyer. Only when you are going to give your money to the reconstruction of Ukraine. Okay, if it's like that, but even if it's unduly frozen bonds, well, you have to sell. Not only you have to sell, but you have to sell to a European client in Europe. So before you start sending your file to the Treasury, well, you need to have a sales contract. Not easy to find. Because who is going to buy with a delay which is not clear? At the moment, we've heard that there are only a few, one or two files which have been accepted in Belgium about those bonds. One, I think, if I remember. Yes, one file. So all the others, thousands of files probably, they have not been accepted. Maybe because they're not complete, maybe because the compliance is not clear. But what about the contracts? How can you, we've done that, but people don't want to how can you define a price and say maybe in 1 year, maybe in 2 years, maybe in 3 years? So to some extent, it's very difficult to handle that. And the question is, what happens if you do not get the decision within the delay? I give the delay. I just send to the Treasury and I said, beware, you have asked a contract. It will be due 30th of May, or you go as far as you can. And if I cannot sell my bonds, you will be responsible. I can call in the responsibility of the Belgian state, even if the regulation says that you cannot call the responsibility of the states. It will be a very nice battle. So I know one law firm in Brussels who has started a procedure in front of the president of the Court of First Instance to request that a decision be taken. I don't know how far it has gotten them, but that's in fact all you have to, I think, one last page. So to wrap up, if you want to defreeze bonds or other assets or accounts which have been frozen, but mostly bonds in Belgium, you have the national procedure, which is a purely administrative procedure, no hearing, no possibility to discuss, to check if my file is complete. They don't answer. They just don't answer. They send you one mail. They send you a receipt for the file in the beginning, and they won't answer to you, never come back. You need, from the scratch, to give the documents I listed for you and an accompanying letter explaining where it comes from, what they are going to do, how we are going to sell, and the guarantee we give. Now, if you get a negative answer, it's the last step. Well, you will not go to European Court of Justice. Let us be clear about that. You only have an administrative appeal, which is in front of the Conseil d'État here in Belgium. And I'm not quite sure that they will be very open to critics to the administration on this point. remains the responsibility of the Belgian state, which I've had quite a few nice files on that, but very hard to get, very hard to prove. So I think, well, that's mainly what I wanted to explain. We are, of course, ready for the questions, and I hope that this more practical approach was also of some interest for some of you. Thank you.
Well, thank you very much, Tamara Kayani and Dominique Grisé. If you agree, we will wrap up the questions in the end so that we follow our path. So I will call on stage William. No, is he? Oh, so are you still happy to speak?
Oh, yeah.
Well, William is an interesting character because he's a criminal lawyer qualified not only in France, but also in Belgium. So the floor is yours.
Thank you. Recently qualified in Belgium a month ago. Registered anyways. So maybe just a couple of personal comments before I get started on this open letter that we launched a couple of weeks ago. As just said, my background is criminal law. Before doing international criminal law, I did criminal law in France, meaning defending people who had or had not, but more often had committed crimes. Crimes could be murder, could be selling drugs, could be raping children. I did that with passion for maybe 10 years. And this is of interest for what I am going to speak about in a minute, meaning sanctions, because I learned there, first of all, that people could, and I understand that, not understand that some lawyers would defend these people. What lawyers do or don't do is something that also can change. I don't do anymore things that I did at the time. I would not defend a pedophile now. Maybe because I have children now. At the time I didn't, but I know people, colleagues who have lots of kids and still defend pedophiles. I would not do it, but that's my own choice. Second comment on my background, I happen to come from an English and French background. My mother's English, and I had a German grandfather who was the only lawyer in my family. But a short-time lawyer because he was banned in 1933 from providing legal services to his clients for reasons of him being Jewish and being banned from doing his job because of that. And he left Germany very early, and that is why my mother's English. And I must say that when I read this legal ban on legal services, I thought of that. Third personal comment is I reached out at the beginning of my Russian sanction work related. I had advised on a Syrian case before, but my first Russian connected case sanction-wise was in March last year. And I reached out to a friend of mine who is an extradition and human rights barrister in London, a good friend whom I've been working with for 20 years. And I said, listen, I've got this case. We're looking for an expert who can maybe say what he thinks about the possibility for leading or non-leading, I don't know, business person in Russia to be independent from the authorities. And he answered, but would that be a sanction-related case? And I said, yeah. And he said, so I think that I won't be helping any Russian sanction-connected clients, nor would any of my human rights friends. I was a bit bewildered by this answer. I do continue to like this friend as much as I did, and I do accept his decision as an ethical one, moral one. And I think that he's perfectly allowed to say what he said. But I also think that it is as well acceptable that some other lawyers consider that the fight that is theirs, that was theirs when they did some other cases, is the same for us today. And my fourth and last comment, and then I'll get to this open letter matter, is following this discussion with this barrister friend, I was invited on some media to comment on war crimes in Ukraine. And a year ago, I was asked whether I thought that a warrant of arrest could be issued against the head of the Russian state. And a year ago, I said, yes, I do think it is possible. And a lot of people were saying, oh, you know what, that is crazy. International justice will never go down that road. I don't know if it's a good thing, a bad thing. That's not today's subject, but it happened. And very shortly after I started to make some comments on the war crimes and saying, not bravely because I don't risk anything in saying so, but very early saying that for me, war crimes had obviously been committed in Ukraine. And then I started to work on these sanction cases, and I wondered, and people asked around me, but don't you think there's something a bit schizophrenic about that? And I gave it a thought, and my answer is very clearly, there's nothing schizophrenic about that, for the reason that I'm going to try to explain now, which is that the fight, would I be defending victims of the war? And inquiries have been opened in France under various jurisdiction arguments. Would I be defending the family of someone killed during the war in conditions that are not acceptable regarding international law? I would be doing exactly the same thing that I'm doing now. And I will just read 2 or 3, if I can find the messages that were posted on LinkedIn regarding today's event. And then I will get to what I have to say.
Yeah, William, you're keeping the suspense here. People want to hear about the letter to the Commission.
Okay, I'm getting there. So, we decided, in accordance with these colleagues, to launch this open letter in order to make it clear that there was a major issue with the rule of law. And what I said in my personal experiences was to introduce the fact that I have never witnessed in the past 22 years what I consider being a system with such lack of rule of law in its functioning. Such lack of rule of law regarding 2 main topics, and Maya Lester touched upon other points, but there are 2 main ones, I think. One is the poor quality of the evidence that is being used by the council and that emerges in what is not a proper adversarial phase before we go to court. And the second point is connected with how this administrative, non-proper adversarial phase connects with this 6 months relisting system, which I call the never-ending story, and we touched upon that already, which is that even if you win, you don't win. Even if you get out, you don't get out. So maybe it's good to start with numbers. Since the 25th of February, 1,082 persons and entities have been listed. And this is almost 4 times more that the total number of people currently listed under the Syrian sanction regimes, for example, in relation to a conflict that has been ongoing for nearly 10 years. 539 persons were listed in less than 2 months by the Council. And we will see when we look into some examples about the evidence that these numbers put together make it impossible without there having been a proper preparation for these listings to intervene. But we know that this is not the case, because even if the US had been warning Europe maybe quite a long time ago that something was going to happen, it is clear that the intelligence services of the European Union did not have files ready. So it is just absolutely impossible that cases were already ready for these listings to take place. And I think that maybe an interesting thing that can be read here regarding what are the tools that the Council could use, should use, and what are the tools that maybe they don't use. And that is the call that we maybe started for all of us to reflect on: do we need new regulations? Do we need new guidelines? Do we need new tools? Or do we need, at least for someone, and that is the question, who, to address the Council with a request that maybe what I'm going to read now is simply taken into consideration as not just being words on a sheet of paper. So, Council best practices, Article 16, the decision to subject a person or entity to targeted restrictive measures requires clear criteria tailored to each specific case for determining which persons and entities may be listed, which should also be applied for the purpose of removal from the list. This is clear wording. Working methods. The measures should target the policies and the means to conduct them, and those identified as responsible for the policies or actions that have prompted the EU decision to impose sanctions. Such targeted measures should minimize adverse consequences for those not responsible for such policies and actions. So there is a link between who is targeted and responsibility for policies or actions in regards to the conflict. Guidelines, Article 13, the measures taken should target those identified as responsible for the policies or actions that have prompted the EU decision to impose restrictive measures and those benefiting and supporting such policies and actions. So there is, in these provisions, clear connection in terms of benefiting or supporting the policies. Such targeted measures are more effective than indiscriminate measures and minimize adverse consequences for those not responsible for such policies and actions. When you connect this with the broader criteria that Maya Lester touched upon already, and we can go in more details in that if you have questions. But we have seen with Russia that the criterions that had already been used, for example, in Syria with a presumption regime, were brought in a way broader way, meaning that now you could not be supporting in any way, not be benefiting in any way, not be actually connected with the guilty authorities of these international criminal actions. That if you are just a leading business person, leading in a sector that is providing substantial revenue to the Russian government, with no clear definition of what exactly leading is and what is a sector providing and what are the tests, what are the thresholds. But what is new is this disconnection between individuals and the policies or the actions that are the core reason of these sanctions. So the conclusion of this connection between the number and the broader criterions and the disconnection between actions of someone and the policies that are criticized is that contrary to what is happening, there is an absolute need that due process and judicial review becomes more rigorous, more effective than if the criterions were not as broad or than if the numbers were lower. And we see that until the Court of Justice made these 4 good decisions for the rule of law, the former government of Sebastopol, the Priskozina one, of course, the Mazepin one, that before that happened, the council in this administrative phase was just not answering anything, and when was relisting, was not changing anything nor explaining anything except changing, and we'll get to that in a second, one verb using the past tense instead of the present tense because we had provided evidence, and we'll get to that now, that, for example, the individual listed had not put foot in Russia in the past 6 years, and that he was no longer CEO of what he was said to be CEO in the first place. But now we received, in the cases that I know about, for the first time, 3-4 pages letter from the council trying to, at least, which is good, I mean, responding not to everything we said, but feeling now obliged to start doing something. So in contradiction with what Michael said, it is working. And if we had done nothing, each of us in our cases, the court would not have made decisions by itself, and the council will not be starting to improve a bit what they are now writing when they send us a couple of lines of explanation. So first thing that we addressed in this open letter is the lack of quality in regards to supporting evidence. Oh, I thought the slides were coming. I didn't turn around. Do you have some slides for me? No? Oh, it's me. I have to do it. Sorry, I didn't know. And I had to do something. For the first part, it was not very important, but maybe now it's more relevant because I'm a total catastrophe with anything. So I just press on that. Okay, so that was what I read. Okay, these were the articles. Sorry for that. Okay.
Well, I'm sure we're going to have all these slides available, aren't we?
Yeah, afterwards. Yeah. Do you think that one can be turned round?
Well, after a bottle of vodka, I think it will work out.
Yeah, so if you can see that one, examples of, that's what I said about, I mean, except maybe in Lesotho, don't know if you guys know where that is. This is a microstate next to South Africa in a recent Interpol case, or in another Interpol case dealing with a South American country. I have never, I said that in my introduction, I have never seen the use of that kind of evidence in any court in the world. And I do think that even in Zimbabwe, they tried to cook up better evidence than that. I mean, it was cooked up, but it was better than that. For instance, in this case, if you can see something, screenshots of a website called rumafia.net, was used. This website, when we received the documents from the working paper, was not accessible anymore. It seems that it had been deleted because we couldn't access the rest, but I imagine that with that title, there must have been crazy stuff on there, so it was deleted. So that is something that was used. Another website was Russian Crime Truth Loves to Act Openly. I don't know if that is the one. Then we also witnessed many screenshots of Wikipedia articles. Wikipedia is not always bad, but in the cases that we dealt with regarding Wikipedia, I don't know if it's that one, and then my glasses were for close range, not for long range. Anyways, I'll read it. We had, for instance, a statement of reason that included a reference to a position, I mentioned that, as CEO of an American company, that the client had actually never been involved with. He was not CEO, he never held shares, nothing. And the only connection with that company was that in 1996, our client had bought shares in another enterprise from that American company. We very quickly realized that this was a mistake and that had been included only because most of our client's statement of reasons was a copy-paste of his Forbes profile that initially included that mistake. And the Forbes profile, after we responded, was modified and corrected. So the truth behind this is that someone behind the computer, when there was need to list individuals, must have, typed Vladimir Putin businessman friends, found this guy, checked the Forbes profile, found that mistake and listed this individual not only on that, to be fair, but the rest is not better. And he's amongst the ones I think we have maybe some hope to get a delisting decision. But that is what happens in real life when you are looking at sanction cases. And I don't need to comment on the fact that obviously it's not that it's not acceptable. It is just that the test, the threshold in terms of professional conduct and seriousness in when you're doing a job must change. They can't carry on like that, and they can't get off with that. They need to be strong positions made by the court, but by any other player in order to say that this is not acceptable. The second big problem that we have identified is this never-ending story thing, which is maybe even worse than the first problem. This goes with this 6 months relisting process. And the consequence is not in terms of rule of law, that the rule of law is fragilized. It is that it is destroyed. And I think I weigh my wording here. And I do not believe, and we are going to reach out to non-defense lawyers. I want to have the insight of people on the judge side. I need to know what, in terms of value, is a judicial review procedure which does not have any consequence when you have an annulment decision, but that because of this 6 months rule, is of no consequence. And we saw that with the Prigozina decision, and we won't have time today to get into the Mazepin consequences regarding interim measures. But here also, I mean, the interim measures for Mazepin were granted on the grounds of the former listing. He has been relisted. So does he have relief on interim for a former decision? Or does he need to file a new interim on the new listing? And the problem with that is that we are always one train behind. So how do we address this, and how does someone get us all out of that? Because, and I haven't looked at my watch. I don't know how much time I've got left. 5 minutes?
Yeah, 3 actually.
3? That will be okay to wrap up. But we need to come up with some suggestions. And when solutions, when I say we, it's not only us defense lawyers, because as I try to introduce it with my personal comments, of course it's about our clients. Of course it's about restrictions to fundamental rights. And of course our clients, their families are suffering grave restrictions to their fundamental rights. But I think that we might even say that maybe this is not the most important. It is important. But I think the most important thing about this conference and about sanction law, which is an absolutely fascinating, exciting, thrilling area of law, which is sometimes I like to think at the edge of the legal galaxy, where we're on the verge of this not being legal anymore or being legal. And this is why it's so interesting and so telling about who we are trying to make things not worse, as I was going to read that on these LinkedIn posts, but everybody can find them. People saying, okay, come and hold your conference in the bomb shelter. And I'd like to conclude on this, because I understand the emotion, but maybe especially in times of crisis, what we need to do when we are a community of democracies, what I was saying about this Zimbabwe, Lesotho experience I have, which has to do with Interpol work. I mean, we are a community of democracies. We cannot afford what is happening now. It's not about our clients. It's about of who we are, how we do things as the European Union. And I cannot believe, and we will continue this discussion with Michael and hopefully with Maya. I hope she will at least help us with her insight, her experience on what we're trying to achieve. And this is maybe my resilient criminal lawyer heart speaking. But we cannot, I mean, we must and we will succeed in something if we believe in what I just said, and we believe in it. Because we have already the sign that the court has stepped in. So we now need to figure out how we can push on to the next steps. And I invite you all, anyone who can bring some good energy, good ideas to help us get the council to consider what are in its own best, the word is a good one, practices and guidelines, what is not only words, and if we need to reflect on what are the new rules that the council has to apply itself, or what are the new processes that maybe we need to put in place, we need to come up with strong suggestions, and I am sure that at one point we are capable of doing better.
Well, thank you very much, William Julier, for this. It was very dense content. It is now time for a well-deserved coffee break and also some polonium-free tea that you will take here in the breakout room, and we will see each other in about 15 minutes for two thrilling speeches held by Gabriel Lansky and Yuri Shumilov to conclude the afternoon. So thank you very much. Un, deux. Yuri, do you want to sum up already now, or you want to jump in? You can sit maybe. Well, ladies and gentlemen, it would be rude to the other to say that we kept the best for the end, but no. But we have two splendid speakers coming up to conclude this thrilling first European legal debate on are EU sanctions going too far. And now the floor is going to be given to Herr Dr. Gabriel Lansky, who's originally from Vienna, but who has been operating throughout the world. He's just told me that he's now doing quite a lot of work in the Middle East and in Dubai. And he will now address, can we be successful in combating discrimination in sanction law? So, Gabriel, the floor is yours.
Answer to this question, yes, but in hundreds of years, I mean, in a long time, we can be successful. Are they going too far? Yes, they do. Let me be a little bit more specific, and let me, like Williams did it brilliantly, let me introduce myself, respective this kind of very important and fascinating topics which we are now working, all of us, on. Yes, I'm coming as William did. I'm coming from the world of criminal lawyer. As a little bit younger guy, 30 years ago, I was defending very big cases between politics and criminal law. And I learned there that, and I'm coming back to the host of this conference, communication is even more important than law. You can win cases in the court, but the client can lose it if the communication aspect is not done. And this is one thing I learned in my criminal lawyer's time. I started as a human rights activist, and then I degenerated by default to be a business lawyer. Coming from Amnesty International, human rights organizations, and learning what I call today lobbying or governmental relations, representing Amnesty International, the United Nations in Vienna, and these kind of things. What I learned in this period of my life, and it's not a learning which I love to do, and I think I was able sometimes in my life to change it, but as a young criminal lawyer who was speaking a lot about human rights, I understood that sometimes the client gets maybe 1 year more prison if you speak too much about human rights. Criminal lawyer the criminal judges hate usually to be confronted with human rights, and they punish the client even more if the lawyer goes for that. But I understood then there are different forums to work on human rights which are quite effective. And I was representing, and I am still representing a lot of cases at the European Court on Human Rights in Strasbourg. In sometimes states, sometimes individuals, a lot of times Article 10, freedom of expression. This is why I was so astonished about the decision about Russia today, which I never saw something like that in my life, honestly speaking. It's incredible, no? I mean, a decision in which the distribution of a medium in Europe is simply prohibited, and in which the court saying in reality just saying one sentence, forget it, it's war. Who cares? Freedom of expression. This is what this decision says. And I remember so many cases I've been winning also in Strasbourg, in which they say, you know what, decisions, freedom of expression can be wrong, freedom of expression is also valid for complete wrong stuff. Even provoking media are free to be distributed. Everything forgotten in the world of sanctions. And then last year in April, a friend called me and told me that a friend of him needs urgently support in sanctions. So I went to the Emirates, and I stayed there for now 1 year, close. Not completely, but we opened a company in the Emirates with a lot of experts, with a nice guys like my friend Victor Kreuzschitz is a former judge of the General Court, like Maria, a former court of the ECG, like professors, having a team there and working on this issue together with a group of, how I call them, ambassadors, former ministers and other guys who can speak with targets. Because you, as a representative of, as we all know, of a sanctioned individual, you cannot speak. You cannot go to a decision maker, they would not speak with you, but others can do it. This is completely legal and okay. And this is what we established as a kind of methodology. What are the lessons I learned from my life for these cases? And then, in some way, honestly speaking, I have to again repeat what William said and bring it to my own bio. As a second generation of a Holocaust survivor, I have a certain understanding of what I do not want to be repeated, and why I see and why I started with human rights, and why I don't leave it even if the pressure is big. Honestly speaking, that doesn't disturb me, that motivates me more. And the point is as simple as that. If individual rights are violated, and if politics starts to violate all the borders of that, what I learned the last 40, 50 years, 40 years, I think it's time to stand up and to speak. And what happened that I don't understand it, and then I will come back to the relatively important legal stuff. I just think some remarks for that, what I feel is the really important thing. We learned very interesting things in our life as a lawyer at university, and after that we learned about the 4 freedoms of the Union. We learned about Maastricht. We learned about human rights, about the European Convention, all those things. And in a magic way, which I can understand how totalitarian countries like Russia function when they eliminate freedom of expression. It's not complicated to understand. I do not understand how in our world of media, where the magic, the diable is sitting, which produces uniformity of published opinion, because it's not the public opinion. There's a tremendous difference in this question about the official opinion in the capitals like Berlin or Paris, and the opinion of people, of decision makers, even if you speak with them. Because if you speak with guys who are occupied with the topic, usually you have a consensus. And even if you speak with people who are one of those who give gas and say, yes, we fight till the last dead Ukrainian, even if you speak with these people, and if you speak with them in a small group, it's quite astonishing. The same people who said, who couldn't be more proud to deliver each day a new Leopard, it's even these guys, when you speak with them in private, so to say, or under Chatham rules, they would say the opposite. So I don't really understand where this comes from. Prognosis for the future of the next half a year, and I'm quite convinced about that. Things will change because things are already changing in politics. We just have to look to Italy, Hungary, Austria, FPÖ. I don't love them, honestly speaking, but it doesn't change it. 1/3 of the population in our country obviously go for a party who is completely sanction critic. Italy is quite complex between Lega and Prime Minister. So, okay, each country is different, but the tendency is clear. Population does not understand why they should pay, don't have the money to pay the energy bill, don't have the money for paying food and all this in order to fight for the democracy in the Ukraine, which is not existing, as all of us know. But there's another issue. But what I want to say is I do believe that the political change in Europe will be here. This will influence the politics. It already does. Our foreign minister already is publishing intelligent things, which I never would believe that he does, but he can. And you can, it's clear to, and we had a discussion in the morning, as far as I remember, United States will change. United States will completely change. It's clear and understandable that the corruption of Hunter Biden is going to be a big topic in the upcoming electoral campaign. So the relation, the understanding of the fantastic democracy in Ukraine and the corruption-free environment, which everybody till last February knew that it's not like this, just the opposite. But so all these stories will suddenly disappear again, and the United States will change politics. And then Europe remains, having given all the business and all everything what was useful in the normal relationship to Russia, will have given it to the United States. United States will have fantastic income with LNG. The dependence of Europe is not going to be from Russia, but from LNG producers. Norwegia is also a little bit winning. But, so I am sure that on the framework of 9 months, this will be different. Okay. What does this mean? A lot of consequences, I think. We are consulting enterprises who are under big pressure to sell their Russian entities, which are profitable. Should they do it? Can you consult as a consultant to sell Russian enterprises because they are Russian enterprises? Or should you consult that they stay in the as a shareholder, as a European shareholder in a Russian entity? Does it fit to the business judgment rule for a board to take a decision to sell for nothing a Russian entity because it's a Russian entity? Who is going to be liable for such decisions? So personalities like our politologist professor are going to be important because these guys will have to have opinions, fairness opinions, whatever, opinions in the file in order to rectify if they sell such entity, as an example. So what I want to say is the political side will change slowly, but then it will change. The legal side, we discussed it shortly. I'm absolutely convinced that there is a radical change in between half-a-year decisions in interim measures like Russia Today and Mazepin or Prigozhin. Now, this is a new world. These are normal decisions of normal human rights believing judges. We know the guys. They are not heroes. No, they are judges and careerists and everything. It's clear, normal people. But they are not people who want to be politicians. And I think that the borderline of that is changing. So I'm a little bit optimistic that the following thing will happen. And we, all of us who are working in this field exactly know, yes, the structure is exactly like Maya Lester was describing it, exactly like this. What does it mean? That in the framework of post-Lisbon, we have a very reduced competence of the courts to interfere in foreign policy decisions of the Union. It is not like in the other cases. It's a constitutional issue. There is a limited competence. So they cannot review and change foreign policy. They cannot. What can they do? They can go for individual rights violations and set borderlines, limits of actions which interfere in basic human rights principles under the Charter of Fundamental Rights, the CFR, under the European Convention. This they can, and they can go, as it was discussed today. They can go on the ground of a plea of lack of a correct assessment. They can go into the facts and they can say, no, this has not been proved, this has not been proved, I withdraw. And I give you an example of my main experience, because I started 2014 with sanction law. I was defending Azarov, the Prime Minister of Yanukovych, against the European Union beginning with 2014, and we have been successful. The ECG turned over the sanctions, but this is what I always called in these years a perpetuum mobile of illegal sanctions, because we had not half a year, we had 1 year sanction period. So we have been losing or winning a case, and he's been newly sanctioned, and we won a case, then newly sanctioned, and all this stuff for 4 years. Okay, but why? How could we win it? And what do I learn from this case? It was completely clear. The court understood at a certain time that Ukraine is claiming to sanction Azarov. They were the third country who initiated the sanctioning of Azarov. And the court started to understand, due to the work which we did, that all the 4 different etaps in which the Ukrainian tried to show that Azarov is a criminal were just bullshit. Those are just without substance. So at the end of the day, the court said, yeah, but you are a third country, you're not the union. We are very happy, and we have this friendship agreement with you, and we love you a lot, and we need to support you. But still, you have to care for a minimum principle of rule of law, which you did not, obviously, because you didn't prove anything, just the opposite. So, okay, sanctions deleted. What I want to say with this is, and I think that this was on the basis of Kadi. Kadi was, in Kadi, the court set limits. And then they tried to explain me in the hearing that yes, Kadi is not valid for us because this is not a terrorist. And I told him it's fantastic. So you are claiming now that protections who are valid for terrorists do not apply for prime ministers. It's quite a strange equation. So then they said in the decision, they said yes, you are right. What's good for terrorists is good for prime ministers. So let us let us take this as granted, and let us explain the Ukrainians that Ukrainian friends that they shouldn't bullshit the court. They didn't write it like this, but this was the result. So what I want to say with this, certain optimism in both points, certain optimism that if in the meantime there's not an atom war coming up, which is in my view unfortunately absolutely possible and a realistic scenario, but if this is not going to happen under this condition, there might be a policy change in half a year to 9 months, and there might be the development at the level of the court might be a basis for reassumption, and might have a certain influence on the political decision makers, which I'm not so sure, because I'm not so sure if they think so far going. But, okay, so this is sorry for certain overview how I see all this. Very very shortly and very reduced, trying to do my job, which I promised. We have 2 big cases in which the discrimination by status is the main point. We have 2 cases, one perfect and the other one semi-perfect, which is doing nothing else than to say, come on, you are the woman of an oligarch, and by being the woman of your husband, you obviously profit from his wealth, and doing this, you are being associated with him. You ask to be sanctioned. This is in all the different articles of human rights. It's just not legal, and this kind of discrimination is, I think, too much. So we have this expressis verbis article in Article 3 of the 269. We have a clear wording about association as a ground, but of course this needs to be interpreted, and the question is how, and the question is if there are any boundaries and any limits to be observed. Sure that this is like this. Sorry. Okay.
Yeah, and then there is another primary law. There's another legal basic, which is the Directive 2000 about prohibiting racial discrimination. Fine, and we have so these two cases which are at the court right now. They are both of them. In one case, it's ridiculous. So the lady has nothing else than as a bad point in her curriculum. She is the chairwoman of a purely caritative association of the group of companies of her husband. Full stop. Doing very reasonable caritative job for kids who had no money, for education of kids, things like that. Yeah? And this is what what the union claims to be a reason enough that she's the chairwoman of the board of directors of this charity organization. And unfortunately, her husband is a billionaire, which is, of course, very criminal, but what can we do? So I think in this case, I'm quite optimistic that we are going, that at the end of the day, we will win this case. And it's not the only one, as you know. There are other cases with the same structure. And I think that Nikita Mazepin as the son of Dmitry Mazepin, Violeta Prigozhina as the mother of Yevgeny Prigozhin, same stuff. And the court obviously will distance from that. I'm quite optimistic with that. So, okay. So we have a certain amount of governing legal basis around the European Convention on Human Rights, around the Directive of 2043. And at the end of the day, it's completely clear that the jurisprudence of the European Court of Human Rights and of the ECG is going to govern these cases. We have Coleman is very clearly going in the same direction. Women are being subjected to direct discrimination due to their status as a wife, and that's the issue. And if they are associated with their husband, because they are the wives of a Russian privileged person. Discrimination based on gender and social status. Yeah. And TAISA is a decision. I don't want to go into details. We can discuss it later. TAISA is quite a very fitting case. It's of course it's not. It doesn't need to be about sanctions, by the way. Those are decisions which are not automatically sanction related, but the principle of the prohibition of illegal discrimination because of status is exactly the same. And these decisions can be are to be applied. These three decisions of the court of the ECG or the General Court are to be understood and interpreted in these cases. Yeah. The distortion of the relationship, the lack of options, the discrimination in comparison of groups of people, all these arguments are relevant and are to be considered. Yes, the normal scala of principal rights after the convention are to be applied if possible. Article 8, of course, family life. Article 1, first protocol, property, of course. Freedom of movement, and probably also Article 1 of the right to property, I was already saying. Okay. Now all those decisions doesn't. I don't want to go into that, but it's valuable to read it, because then you really understand what the borderline is going to be, which the court is going to apply. Yeah. What is the conclusion of all that? The conclusion of all that, in my view, is that exactly in this group of cases, I do believe that there is a real hope. I think that this is too much. One of the cases in which it is too much. I think here there is a real hope that the court will not follow the argument. One of our main clients since 1 year, unfortunately, telling me all the time over, what should I do? Should I divorce from my wife? We're happily living together 20 years. Does the union force me to divorce? I mean, very very much at the point. And there is a second emotion which is completely understandable of these guys. Yeah, and my wife is a citizen of European Union state. So what should I do? In the Union, I cannot live. In Russia, I cannot live. Where should I live? So all these feelings of people lead to a complete disruption. And what I really believe is that this starting with February last year, a multipolar world. It's not a unipolar world. It's a multipolar world. And what is going to happen is that the trade, business, work, labor, everything everybody is going to be with each other. And thanks to the fantastic success of European Union sanction policy, China, as it was said today, China and Russia are one world. African countries, they understand perfectly why they are not in our team, because they remember, different to Western countries, they quite nicely remember the history of colonialism, and they remember how they were treated and how they are treated, and they just obviously don't have any interest to join this club, which is completely understandable in my view. And this is why I think some of the people do not understand how many billion people are living in the world. I think it's around 9 billion. And if you read our newspapers, you have the impression that close to all the 9 billion are very happy to be in our team. They are not. The difference in team is just the opposite. It's between 2 and 3 billion versus, I don't know, 6. But this is quite a simple mathematic, which is easy to understand. And everybody would understand what the dramatic geopolitical consequences of this bullshit are. Thank you very much.
Well, thank you very much, Gabriel Lansky, for sharing this very dense expertise and experience of yours. And indeed, I was talking recently with Lebanese and Syrians, and they explained to me that they were very pragmatic, because in order for men and women to have intercourse, they found imams who would marry a couple for a couple of hours. So maybe you could be divorced, during a hearing for a couple of hours, in order to meet your arguments. So more seriously now, we're going to welcome to the floor Yuri Shumilov. Yuri has been a thriving lawyer in the City of London for many years, and we now have the pleasure to welcome him in the capital of Europe as a partner for Acquis EU Law and Policy, and he will handle the corporate part of the sanctions. So, floor is yours, Yuri.
Thank you. First of all, I wanted to thank Uwe for organizing this conference and for having me on such an illustrious panel. That's very pleasant. And one may ask, why does a partner of a law firm talk about the corporate angle? And well, beside, of course, Uwe having to fill a speaking spot, but the answer to this is because in not so recent past, distant past, I was a corporate counsel myself. So in preparing this talk, I've picked up the phone and called my former peers and colleagues in Moscow who are general counsel in various businesses and companies. Some of them are sanctioned, some of them are not sanctioned, and just asked them how they've been right? And what they've been feeling all this year, and what grievances they have. And I think you could categorize those experiences broadly in 4 baskets, depending on the type of company you were speaking to. And the first, these are companies that are sanctioned, right? That are either directly sanctioned or under direct control or ownership of sanctioned individuals. There are the companies that are not sanctioned. Then there is a fairly curious category of companies that are not sanctioned, but there is a sanction element somewhere around, right? There might have been a CEO or a former CEO that was sanctioned, or a minority shareholder that is or was sanctioned, or maybe a minority shareholder that is sanctioned somewhere else, like in the US, for example, but not in the EU. And there is a fourth type of companies, which is kind of separate beast, and I'll talk about it at the end. These are the Russian companies that are subsidiaries of EU companies or joint ventures of Russian businesses with the EU companies. So taking them in turn, I mean, I think the experiences of companies that are sanctioned are pretty simple, right? They sort of their business operations in Europe are pretty much it's just assets frozen. They don't do any business with Europe, so that's pretty simple. But I think that there are 2 experiences from these group of companies that have been referred to. And the first one is a fairly unexpected one, I think, is that many of these companies are have been unable and are still unable to take corporate decisions in Russia because of the sanctions. Even though they are based in Russia, their assets are in Russia, and the UBO is in Russia, although it's sanctioned, they're still unable to take corporate actions. And this is because for years, the Russian businesses, many of the Russian businesses have been structured in such a way as to have a holding company somewhere in Europe, say in Cyprus. And although there's been a push in the recent years to move those businesses outside Europe and those holding structures outside Europe, many still remained. And the resulting effect was that, and still is, that there are operating companies and plants and factories in Russia where the immediate shareholder is in Cyprus. And you can't take any shareholder decision, any decision that requires a shareholder resolution from Cyprus, because the directors, the professional directors in Cyprus simply refuse to do so, and you can't change them, and you can't move the shares, and you can't do anything. And then you're pretty much stuck. But I think what Russia has been doing in response to that, and I think they've been introducing some regulation, which is coming to force now, allowing to basically bypass this European level and for the ultimate UBO to take corporate decision right at the level of the sort of the operational asset in Russia. But this is still sort of in the works, and the issue is still pertinent for many Russian businesses. The second issue is that is often referred to is effective inoperability of derogations, because sanctioned businesses do apply for derogations for certain transactions, for certain payments to them or from them, but then having obtained that derogation, even sort of after a 3-4 months waiting time, is just totally rendered ineffective by the banks. The banks just don't process them, telling it's against their policy, right? So basically, or they take some difficult approach. I had one example that I heard from a colleague of mine in a big, a very big non-sanctioned Russian business that interacts with Europe a lot. They had a situation where their sanctioned European counterpart obtained a license in Europe to pay them in Russia, and the license was for like 100 euros, for example, just X amount, and there was some miscalculation, and the ultimate payment had to be by 2 euros smaller than the amount quoted in the license, and the banks just stopped the payment and requested a new license. So, and there are and this is another circle of several months obtaining a new license. So there are multiple examples like that. So I think the inappuracy of the derogations is frequently quoted, and effectively how it looks like is that the banks are effectively, by their policy, they are able to nullify the effect of derogations. That's what's happening in reality. So the second group of companies is the companies that are not sanctioned. And these are obviously mostly affected by the sectoral restriction of the regulation 833. And many people referred to inability to access engineering services. I think was fairly painful, especially for some of the kind of more industrial players I was speaking to. Export of equipment from the EU is another example that was frequently quoted. And essentially, they have the same issue with the regulators, that sort of exporters err on the side of caution and to treat even the equipment that is not listed as potentially dual use, and then you end up with the regulator waiting for a license for months and months and months. So that's what's happening in reality. So what do the companies do? Well, I mean, it's been referred here today several times. I mean, they just turn to China for engineering services and for equipment. And yes, President Xi was in Moscow with a state visit 2 days ago. So one clear effect of sanctions is obviously the closer ties between Russia and China. Well, ban on legal services is, of course, very frequently complained about by Russian lawyers. And well, perhaps it was a function of kind of the focus group I was talking to, because that was all kind of general counsels in Russian businesses. And for sure, they were kind of worried about legal services ban. But I think the interesting angle which they suggested to me is the following. I mean, they ask a fair question. They say, look, we are not sanctioned, and hence we are able to transact with Europe, at least with respect to certain transactions, those that are not prohibited, right? So we are able and allowed to do it, but yet we're not able to take legal advice with respect to those transactions. So how could that be? So even leaving aside the broader question of the legality of the legal services ban and its sort of, a compliance with the broader notions of the access to justice, I guess at least the most burning technical question for them, at least, is make the exemptions broader, not to cover only the court work, right? The kind of the contentious work, but at least to cover all those transactions that are not prohibited by the regulation 833, because otherwise it just doesn't make sense. Which I think is a very fair point. In the same vein, I think the point that's been made to me is about beside the regulation 833, about the actual practical ability to transact with the EU for those businesses that are not sanctioned, because again of the banks, right? Almost all Russian banks by now have been sanctioned and therefore can't really process payments into the EU or receive payments. And of the major banks, it's only Raiffeisen and Unicredit that still remain. And you've probably seen the news. I think it was just last week that Raiffeisen is also considering an exit. And actually, beyond that, Raiffeisen stopped accepting new corporate customers in Russia. So if you're a Russian business and you're not lucky enough to have had an account with Raiffeisen before, and you want to transact with Europe, you're stuck because you can't pay into Europe and you can't receive a payment. So, and that renders the sectoral restrictions basically, well, they're not sectoral anymore. You just can't transact with Europe because of the operational issues, and that's all actually very pertinent to all of us here lawyers, because I mean, I think many of us depend on Raiffeisen being operating in Russia. So I think, and there's also, I think, with the banks, there's also, although it's not the topic of this presentation, there is this practical issue of the banks has also effect on the human rights, because, like, one of my clients, for instance, was wanted to pay for a sanctioned individual wanted to pay for medical services in Europe, and he was simply not able to because his bank accounts were in Sberbank and VTB, and it's just not possible for him to make that payment. It's just not being processed through, and Raiffeisen, even in Russia, wouldn't open an account for him. So you just kind of end up being stuck with practicalities that that have become so difficult as to actually render some of the protections afforded invalid. Some of the more dramatic stories come from companies that are not sanctioned but have some sort of a sanctioned element. And as I said, it could be like a CEO that is under sanction, or it could be a CEO that some earlier CEO that has been sanctioned, or a minority shareholder that may be sanctioned not even in the EU. And I think a term overcompliance often is referred to, but I think the situations of these companies go beyond that. I think this is not already a degree of overcompliance. That's more sort of in the realm of arbitrariness, I think, because I'll give you a few examples that I'm aware of. For instance, we're aware of companies that are not sanctioned but have EU operations, right? And they had projects in Europe but had instantly, for no particular reason, visas canceled for their people, right? Or we've had companies where there is a sanctioned shareholder that has divested of its ownership, but yet, and the company is treated as non-sanctioned by the council, yet some member states take a different approach and disregard the divestment as sort of artificial and still treat the company as sanctioned and freeze its assets. So we have other cases where the company is not sanctioned in the EU, its shareholders are not sanctioned in the EU, but a few minority shareholders are sanctioned in the US. Again, several member states just effectively take a voluntary approach of enforcing EU sanctions. They don't, of course, do not phrase it this way, but still start blocking assets. So, and the list can go on, and I think there are many examples like that. So I think just after having those conversations, I was trying to kind of generalize with a conclusion, right? What is common amongst these examples, and where is the, root of the problem, or at least sort of areas where clearly some fix is needed. And Uwe asked me to be constructive, so I'm trying to be constructive. So I think in terms of roots, well, the first and obvious one, again, has been cited by Maya before and by others, that there is one body making the rules and 27 bodies enforcing it. Right? This is bound to create confusion, and I'm not so sure whether the initiative to create the European OFAC will be beneficial in broad sense, but at least maybe it will help in a more efficient manner of administering sanctions and derogations. But that initiative is obviously going to take ages to implement. So what is the quick fix? And I was trying to think outside the box, but I don't know what about your experiences, but my experience is that sometimes clients, especially clients that are kind of novice to the topic of sanctions, they call you and say, like, look, can we obtain some kind of a certificate from Europe that we're not sanctioned? Can we do that? Like, can you organize that? And I have to explain that it's not possible, that there's no such sort of procedure. Well, maybe there has to be one. Maybe there has to be one that allows you as a non-sanctioned company to undergo some sort of due diligence and actually get the certificate that you are not sanctioned, which would be binding on a kind of pan-European level. So this is the first thing that kind of comes to mind. Well, the second obvious problem are the banks, right? You need to do something with the kind of freedom of the banks to ignore the law and ignore the derogation. So what can you do? I mean, there seems to be that there is a need for some rule that would effectively bind the banks to effect a transaction if, for example, at least if the transaction has been cleared by the regulator. I think as simple as that. If the transaction is cleared by the regulator, you're bound to process it. Or, for example, if my idea of a certificate is ever realized, a transaction with a company having such a certificate is also bound to be affected. Maybe that's at least this could allow to unclog some of the most some of the most obvious problems with the administration of the sanctions. If you go fantasize even further, I mean, one could think about some sort of a special banking institution like Bank of International Settlements, but just for the handling of the sanctioned payments and processing frozen assets and things like that. And that could go some way to reduce the payment link problem with the Russian banks. So, I mean, I think there is space for some quick fixes, but I think there's all hinges on the political will to implement them. So I think just to conclude on companies, on the fourth type of companies, of European companies that are present in Russia, either through subsidiaries or joint ventures with the Russian partners. I think this is this is a kind of separate topic, and I think you could fill in a whole conference on it, frankly, because there's so much specificity around it. For example, there are issues around if you want to exit Russia, right, as a EU company. There are issues and procedures around regulating that exit. You need to go through a regulatory. You need to go through the governmental commission. You need to show that you've done a sort of you're selling at a certain discount to the market price, so on and so forth. So there's like a list of requirements that are there that you need to comply with. And but then there are more nuanced issues, like for instance, some of the exits provide for a buyback call option. So many companies exiting Russia effectively agree that at some point in time they can kind of buy the asset back. And then how do you go about enforceability of those options? Because just last week, I think, there is a new law adopted in Russia that where you have such a buyback option, you need another decision of the governmental commission to enforce it. So how do you go about structuring these? And there's a separate question and discussion to have. And again, there are cases where, for example, there are JVs between EU companies and the Russian companies based in Russia, and these JVs are heavily dependent on some software or managerial services from their European counterparts. And when European partner leaves or sells, there are usually some sort of a arrangement on continuing provision of those services. But then what if they fall within the sectoral restrictions? How do you go about that? So what I wanted to say by that, I guess, is that I don't know if you want to have your second legal debate about European companies still present in Russia and sort of the issues that they're facing. I think that will be a very interesting topic to have, but I guess that warrants a separate discussion. Thank you for your attention.
Thank you. Thank you, Yuri Shumilov. We have picked up the time, and so we do have 15 minutes for a debate with our last speakers. So can I call William and Gabriel back on stage, and so we can have an exchange with them. While you're thinking about the questions you're going to ask them, I'm going to start, and I would like to start asking a question to Tamara and Dominic. We've addressed the high-hanging fruits, so the oligarchs and so on. But what about the thousands of Russian citizens that are living in the European Union? What about the young fellows that have migrated, to escape the war? What would be your recommendation for these people? Because among the hundreds of Zuschauer watching online this seminar, there are many of them. So what would be your recommendations for the Russian citizens present on the EU soil?
Thank you, but basically I think we go back to what has already been said, meaning that I have taken the image of the bank and the banker and the clients such a bank would have. Now you can clearly make the same reasoning, the defreezing reasoning for an individual person, even if that person has just a few bonds. So the way would be the same, provided he is himself not on the lists, provided the bonds are not on the lists. Then if he finds a guarantor, if he can give the elements of compliance requested, and if he finds the way to sell his bonds, well, he could himself initiate a recovery, would say, procedure in order to obtain to be allowed to sell, because it's the only way out for the moment, to be allowed to sell to a European citizen. So it can be done on an individual basis as well as by the banks. But of course, I mean, the cost of all that is probably much too high for the ordinary folk you mentioned, who has just worked and bought some bonds which are via the banks now in Euroclear in Belgium. So the most reasonable solution would be the solution we mentioned, but of course it's a kind of organization. So with the help of the bank, or an organization of clients of the bank, when the bank is listed, of course the bank cannot do it or cannot ask us to do it. It must be the people who have invested themselves who must then start a proceeding. And from what I've heard, at least in Belgium, from the Treasury, we might be able to find a solution to make global compliance programs for a big number of people. We were talking about 80,000 customers a few minutes ago.
Well, I think, what? Yeah. Well, I think what would be my advice to Russians living in the EU? I mean, I am myself one. So I think my advice would be just to say, it's not that bad. I mean, you could don't be afraid, right? There are issues, of course. There are some overcompliance, but if you kind of bash it on the head and be persistent, and I think you could still succeed. So that's going to be my advice.
Interesting. Well, let me jump to another question and address to Gabriel. Gabriel, actually smartly enough, you open up an office in the Emirates, in Dubai, and probably because there is a large diaspora. Actually, it's very interesting because it's a diaspora of both Russians and Ukrainians. So you have like a triangular strategy between Russia, Dubai, and Europe. Can you explain what the benefits of that strategy is?
Let me start with a primitive example of my daily life. In the fitness center in the tower in which I'm living, you have usually, I don't know, 5 to 10 Russians and 5 to 10 Ukrainians doing with their trainers at the same time the fitness program. And they do it close to each other. And the Ukrainians have all of them. Some of them have their Ukrainian flag stuff on their in their fitness clothes. So it's quite an interesting environment. but it has something of something productive. I mean, there's some element in that which shows that people can, in spite of geopolitics, can live together, and it seems to be like this there. But coming to your question, it is very clear. I think that few countries worldwide have taken their right to be neutral and all against all of those. There are tremendous pressures, including the UAE. These countries are UAE and their Emirates. This is Turkey in this quite relevant way. It is Serbia. These are the jurisdictions in which we already started to open company also. I do believe that unfortunately, due to the development, at least this is our corporate strategy to try to be bridged wherever it is needed. It doesn't change the simple fact that we are bound to European Union law, which we, as European Union citizens, we have to apply, and we do apply. So this is not changeable, and this is what we have to do and do. But on the other side, it's for a lawyer. We follow always the clients. I always did in my life, and this is therefore it is reasonable to do it. The situation in UAE is not only simple because they are over formalistic. It's very difficult to they have for everything, including breathing, you need a license, and you need. They're very, very interesting professions. There is a special guy who is only here for bank account opening. He's a bank account opener. It's our own job. And you have a pro. This is a guy which is Indian guy which is sitting in our office and is doing for nothing else responsible for then making licenses, organizing licenses. So over formalistic environment with a partially quite corrupt, complicated system with the banks, etc. So it's not. It's not fantastic, huh? And there's not the rule of law there is not given. It's not very easy to consult somebody to buy real estate because the titles are so complicated, etc., etc. There are hundreds of reasons to be cheated. So we started to have a kind of network of Emirati friends and consultants of local lawyers who help us to understand this world nicer in Dubai.
The concept exists.
Yes, but you know how it's in European Union. So honestly speaking, we do not have the right to be very arrogant teachers. Yeah.
Interesting. Are there any questions from the floor at this stage? Uwe.
Well, a question to William. William, you were telling us that the letters that you can get back are getting longer. It's not just a 3-line letter; it's more a 3-page letter now. So, what do you think? What kind of letters you will receive in about 12 months?
I didn't get the beginning of your question about what was long.
Because you were telling us about letters that you get back, replies you get back.
Oh, okay, from the council.
Right, from the council about delisting.
Hmm.
As I understand, there was a paragraph, and now those are 3 or 4-page letters now.
Yes. After being optimistic, I'll be a bit pessimistic again. I don't expect much from the council. Yeah, no, I don't expect much. My experience, generally speaking, facing, I'll call it prosecution authorities, is that they do not change too much their positions until a real judge does not step in. To be perfectly honest, and that is a bit off record, we're not doing that as much because we think that the council is going to amend. I don't think it is, but I think that we're making something exist. It's beginning to exist out there somewhere, thanks to you also. And I do think that it is going to help things to go in the right direction. I hope I'm wrong, but I don't think the council will change too much. But I think that, and I was thinking about that after Maya spoke, which is if it does not benefit this time, it could benefit sadly for the next round of sanctions, because sadly there might be other countries after Russia, and we are using Iran, Syrian, Venezuelan, Burman case law, or not Burman, I'm not sure there's been decision. Yep. We're using, I mean, when we got started in my firm, the first thing we did is I asked my team, I want a comprehensive table of all decisions on all countries rendered on a criterion that is similar to this one. And that's how you work sanctions, because it's case law material anyways. So if we don't get there, maybe on all of our cases, case law is going to build up and it will be useful for the next round. Maybe there will be new inventions about new criterions, and we'll see. But I mean, the rule of law does make its way within the sanction law environment. So we're working hopefully for our clients now, but we're working for the construction of the system and for the next rounds. Then we'll see. I mean, next step is we are going to reach out. We haven't decided upon that completely, but we're going to come out within maybe 10 days or 2 weeks with the help of all the colleagues. And I think we're going to have more colleagues coming in, hopefully, thanks to this event also. Shoan and Salomé are coming on board, and I hope we'll have more. But we're coming out with another draft within 2 weeks, and the idea is to send this draft, which will be more consistent with the assessment of what is exactly not functioning regarding due process, and with suggestions of what can be changed, which is not revolutionary, but in terms of how can we improve, and I'm sure we can, and try to address this to players within the institution who might want to have a word. We're thinking, for example, of the European Ombudsman. I'm not absolutely sure what he could do, if he could do something, or she, because I think it's a lady, not sure. But anyways, we're discussing that internally, and we're going to see whom we can try to speak to. And then maybe by operation of luck and a bit of magic, the council will delist a couple of names, not only family members at one point. That would be an achievement. And maybe they will, when they understand that the wind is maybe now blowing not in the direction that it was blowing before, which is in their backs, but that is going to blow the other way.
Well, magic in Brussels is called lobbying. So you had another
Yeah, that's
question?
another hot topic. Got enough problems like that. So.
Anna, you had a question?
Yeah, maybe naive one to Dominique and Tamara. How do you finance the compliance check before you decide whether you can take on board a client?
It's on. It's on.
We basically take it. We are regulated. So before anyone takes on a customer in the EU, if we are compliant with the rule of our profession, you need to do the full compliance check on any of your customer. So for us, it's just an investment to be able to do our work properly. we do always the full control before even sending a proposal to a potential prospect. So there will never be a proposal issued by an email or on official paper without having run through the controls. So that's basics for us, and we have a full team for compliance. And more and more regulations are happening over the last 10 to 15 years. And you need to be in this business to have a strong legal and compliance team. It's not possible to do otherwise. And it takes investment for having a subscription to all the system that you have. You need to have a strong IT infrastructure. You need to have a programmer. You need to be able to filter data, to program data. And then you need to have people who can analyze it. So it's expensive today for a company to try to be up to date.
And this is why lawyers work with people like Tamara.
Any last question maybe before we wrap up? Well, if not, maybe I would inspire my conclusion by a proverb, a sentence from the 70s in France, which was a punchline that states, en France, on n'a pas de pétrole, mais on a des idées. In France, we have no oil, but we have ideas. Maybe if we do an analogy at the European level, we could say, in Europe, we have no dictatorship, but we have sanctions. So I would like to thank this illustrious panel of speakers, and I would like to ask our chairman, Uwe Wolf, the CEO of NAΗMA, to make a final conclusion and maybe explain again why we had this first summit and to what is the purpose of NAΗMA as a company. So thank you very much.
The purpose of NAΗMA is pretty simple. It's about communication, legal communication, and that's basically it. And helping also the lawyers to support their strategies. That's basically in a nutshell. Everything else is on my own website. So what we've heard here is many interesting and perspective-altering talks today. And I myself pretty proud to have assembled my team, so many great speakers. And I came to the decision during the day to pick up on that and come up probably with a similar conference in the near future on that. It shouldn't be longer than a year to see what happened in between in those 12 months. So I want to thank you all the speakers and all the participants for being part of the conference. And you made it very special, I have to say, really. The live stream will be available so you can on our website. So you can check it out. I mean, sometimes you will have to, you want to review a talk. I will definitely do it. And I think it's going to be there for quite a while because it was really a lot of stuff. Yeah. So please stay in touch with us. We will stay in touch with you and have a safe trip home. And again, thank you so much. Thank you.